of 2014, 1306 2 K. Moore versus J.J. Zuma, and Gambijano versus J.J. Zuma.
Good morning, my ladies. Good morning, my lord. Just housekeeping appearances are the same, except for those people who were excused. Just as a matter of housekeeping, my ladies and my lord, we will, well, firstly, we have had a discussion with our learned friends about time so that we can ensure that we finish. So we will not insist on taking a full day like they did. We will allow them, they've agreed that they will need about an hour, they'll need about an hour to reply on the basis that the amici don't have a right of reply. And so if I start at the end, we will endeavor to finish by 3 so that we allow them that space. It's, well, I'll be sure, I'm trying to explain that I'm going to be shorter than them. Yes, they took the whole day. Yes, but we want to accommodate, and in that time, my lord, particularly we might not be, if the court adopts the same attitude of not asking questions, and we might even be shorter. Yeah, but we're assuming that there'll be some engagement. But to come directly to what will happen next, as I indicated earlier, Mr. Masuku will go first for about an hour just to deal with amici, all the amici. Then I'll take it from there on the actual 2 cases, as the court pleases.
Honorable Justices, we had considerable, wide-ranging, extraordinary submissions made by the amici, the media amici, and Helen Suzman Foundation, and the Democracy in Action. And it's important that we set out the context in which we make our submissions in response to their submissions. When we offered our consent to have the amici granted the status of a friend of the court, we were aware of these extraordinary, antagonistic attacks that the amici were taking against Mr. Zuma. But it was practical for us to grant them consent so that the court, in its exercise of discretion, may decide whether, in fact, they have submissions from a friend of the court. Having had the submissions of amici, can this court say that it has friends in the media or friends in the submissions of the Helen Suzman Foundation? It's important to reflect on the role of amici, because courts over and over again emphasize that the role of the amici is to assist the court in its adjudicative process. It is to assist the court reflect on the dispute and to come to what the court say is a fair and just conclusion. You recall, Honorable Justices, that courts sometimes invite amici because before it comes up a complex matter for which it's justified to invite an amici. So the purpose of the amici is to enrich the court's thinking of the issues and the dispute. In return for the privilege of participating in proceedings without having to qualify as a party to the dispute, an amici has a special duty to the court, and it is to provide helpful and cogent submissions that may assist the court in its reflection of the dispute. So it would be an error for the court to invite into its adjudicative process a party who masquerades as a friend of the court, when in fact that party is an opponent of one party and is entirely antagonistic to the other. If the court were to admit submissions that assist a party before it, it would rightly be accused of lacking in independence, impartiality, and fairness. That is why in the Constitutional Court, in Ex Parte Institute for Security Studies, in Re S versus Basson, 2006, Volume 6, SA 195, the Constitutional Court at paragraph 6 held that the footing on which the amicus is heard is that the person will make submissions on law and relevant facts which assist the court in a way in which the court would otherwise not have been assisted. So the main mission of the amici is to be a friend of an independent, impartial court exercising independence and impartiality on the issues, on the dispute before it. So a friend of the court has loyalty only to the court and must make submissions in a manner that reflects the neutrality and the independence of the court for whose benefit the amici has been admitted. To take an entirely antagonistic position, to berate one party, to attack the bona fides of one party by an amici is unseemly. It is not the role of the amici to attack one litigant under the cloak of being a friend of the court. So an amici must make submissions that are relevant to the issues before the court. Those submissions must be useful to the court. Those submissions must be different to those of the main parties to the case. But as Moseneke in the case I just referred to said, former DCJ Moseneke said in the case I just referred to, he said that an amicus may advocate for a particular outcome in a case, but when they do so only for the benefit of the court, and they do it exhibiting the neutrality and the independence that a court is expected to when they exercise when they assess the submissions of the amici. So the fact that amici has been admitted by consent does not absolve this court from carefully determining whether they have friends who have been admitted to assist the court's independent and impartial adjudication of the matter, and not merely added opponents against one party. I emphasize that it would be inimical to the true attributes and nature of the court to admit a person as an amici, as his friend, who is an opponent of a party seeking justice before that court. Against those brief submissions, we contend that the admission of these amici into these proceedings does not absolve the court from determining whether they are indeed its friends, whether they are indeed friends of the court, and not merely opponents of Mr. Zuma. who are here to load it against Mr. Zuma, who are here to add more condemnation on Mr. Zuma's private prosecution. You would have heard Amiki's even choice of language in attacking Mr. Zuma. We submit, Honorable Justices, that the media Amiki and the Helen Suzman Foundation have spectacularly failed to utilize their status as a friend of the court to make submissions that are helpful to the court, that would enhance its adjudicative view, its adjudicative process, or even enhance its independence. The perception that the court must be independent is very important. And when it has friends assisting it who are antagonistic to one party, the court ought to be careful how they receive those particular submissions. You would have seen that the Helen Suzman Foundation goes as far as falsely alleging that the private prosecution of a prosecutor is an attack on the entirety of the NPA. That's an extraordinary, they in fact got as far as saying that the private prosecution is an attack on our constitutional system. That's entirely unfair. It's not founded on fact. It is not the role of an Amiki to come to court to condemn a party who is exercising what is recognized in law as a right of a party to have a dispute resolved by an independent court. A court must not have no such friends. These ad hominem attacks on Mr. Zuma cannot be met by a court or even condoned by a court, because the insults heaped on Mr. Zuma cannot truly reflect the dignity of the court or enhance its independent and impartial evaluation of the main dispute. So it's common. Everybody knows that an Amiki, who's a friend of the court, is not admitted to bolster the case of one party against the other, because a court may not have such a friend. So a court would be acting contrary to its nature and constitutional mission if it accepts the submissions of a party that does not reflect in its submissions an independent and impartial evaluation of the facts and the law that is relevant to the dispute for which must be adjudicated by the court. I refer again to what Justice Moseneke Deputy Chief Justice Moseneke, as he then was, who concluded that the Amiki may urge a court to reach a particular outcome. Here is the qualifier. And he says, but it may do so only in the course of assisting a court to arrive at a just outcome, and not to serve or bolster a sectarian and partisan interest against one of the parties in the litigation. Let me begin. I will, in the course of making my submissions, I will quote from. I will reflect on the insults. I believe are insults that should never be made by a friend of the court. But let me begin by what the Amiki do not make submissions on, in order to provide the context of why we respond the way we do to their submissions. The Amiki do not allege that the crime in Section 41(6) of the National Prosecuting Act does not exist. So they are not here in court saying, no, that crime does not exist. They know the crime exists. They would be hard-pressed to resist the tried proposition that where a person, whether it is a journalist or a prosecutor, without permission of the National Director of Public Prosecution, or a person authorized to disclose information within the NPA, where that person would be sorry. Let me restate again. So they would be hard pressed to resist the proposition that where a person, whether he's a journalist or a prosecutor, without the permission of the NDPP, or a person authorized in writing by the NPP, discloses to another any information which came to his or her knowledge in the performance of his or her functions in terms of this act, which is the NPA Act, or any other law, the contents of any book or document or any other item in the possession of the NPA, or the record of any evidence given at an investigation, shall be guilty of an offense. Section 41(6) does not discriminate. Doesn't say that if you are, it uses the word anyone. It doesn't say that there's a special place for journalists, and this will come to how we deal with their contention on Section 16, where the contention is that Section 16 is Section 41(6) must be read in such a way as to preserve the right under Section 16. Let me make this point right up front. Section 41(6) does not prohibit disclosure of information per se. It prohibits disclosure of information without the permission of the National Director of Public Prosecution or his or her authorized individual. That's what it criminalizes. The defense of Mr. Downer, defense of Ms. Mon, could have simply been, we have this information from the NPA, we've got, here is the permission we got from the NDPP. That would end the case against them. So, to suggest that there is an attack on Section 16 is a misreading of the law. Now, Mr. Boff will deal with the formal, whether Mr. Zuma has complied with the formal legal requirements for bringing a private prosecution against Mr. Downer and Ms. Moore. But for purposes of my argument, I'll assume he has. What appears to ache the amicis on which they peg their submissions is his state of mind when he triggered the process of private prosecution. They want to suggest that he had an ulterior motive. He said somewhere in Nkandla and cooked up a scam or a prosecution scam or what they call a sham, and they call it a game. The Helen Suzman Foundation prosecution. They call this a game. Mr. Zuma has a game to play. He sat at Nkandla. Former President Zuma sat at Nkandla somewhere and cooked up and manufactured a prosecution scam, prosecution sham, in order to avoid accountability, in order to avoid, or in order to play political games, as they put it. That's an extraordinary statement coming from a party who is supposed to be neutral and independent party. So it does appear to us that amici do not contend that Mr. Zuma has not complied with the formal legal requirements. Over and above those formal legal requirements, they contend that you ought to look at his motive. And if you should come to the conclusion that he has ulterior motives, what you need to do is to then dismiss this application, interdict set aside the summons and stop the prosecution altogether. The Helen Suzman Foundation goes as far as contending that even if this court were to hold that there is a prima facie case for a prosecution under Section 41(6) of the NPA Act, Mr. Zuma's alleged ulterior motives or ulterior purpose for bringing the prosecution vitiates the lawfulness of the prosecution. In other words, they say even if you were to come to the conclusion that prima facie there's been a violation of Section 41(6), look at Mr. Zuma's conduct. On his own conduct, they say read in ulterior motive. Find ulterior motive. And when you do find the ulterior motive, set aside the summons and stop the prosecution. What they have done, over and above the legal requirements for bringing a prosecution, is to impose ulterior motive as a jurisdictional requirement for bringing a private prosecution. They are essentially suggesting that ulterior motive can vitiate a lawful prosecution, because the submissions made by Helen Suzman Foundation is that even if you are convinced that there is a prima facie case that a prosecutor of the experience that Mr. Downer has violated Section 41(6) in that he has unlawfully disclosed documents which are in his possession, which are obtained by him by virtue of that position he has. He has disclosed to a journalist. Even if you are to find that that is the case, if you should find that Mr. Zuma has ulterior motives for prosecuting Mr. Downer for that offense which is set out in 41(6), you must then set aside the prosecution. We can assure this court that Mr. Zuma has tried many times, that Mr. Downer, in many instances, points it out. Whenever he has an opportunity to point it out, he points it out. That Mr. Zuma seeks to perpetuate a political conspiracy against him in this prosecution. Of course, it doesn't refer to the only evidence of the National Prosecution Authority by Willie Hofmeyr, where it's clear that the NPA in relation to the criminal prosecution of Mr. Zuma is a crime scene. And Mr. Downer, from the beginning to the end, has been a prosecutor while the crimes were being committed within the NPA. So the amici is here in a very partisan manner, very antagonistic manner, to bolster the case. In the case of the media amici, you will have noticed that they have issued, Mr. Mpofu will deal with that, but they have issued media statements making it unequivocally clear that they are here supporting Ms. Moore. The media is here supporting Ms. Moore. So what they have done in order to support Ms. Moore is to create factual basis for it, which is not borne out by the facts. They have created a factual basis, one of which is that Mr. Zuma is here prosecuting Ms. Moore, a seasoned journalist, for ulterior motives and to silence her. You'll be glad to hear that even yesterday when we were here, Ms. Moore was busy on News 24 sending out information. In fact, what I'm saying right now is probably going to be in the news today. There is no evidence whatsoever of any threat to Ms. Moore as a journalist. No single piece of evidence. The only evidence they try to hang on is the evidence that comes out from social media, of which Ms. Moore injected herself into. On her own, she goes into social media. And a friend and colleague of mine said social media is an ungovernable space. It's cruel in social media. So when she gets what she gives, she then complains that Mr. Zuma is responsible for it. That's manufacturing facts on why this prosecution is here. The prosecution is not a prosecution of Section 16 constitutional right. It is not. It's false to suggest that somehow this private prosecution must be seen as an attack on the media. There is not a single litigant in this country. And one of my respected senior counsel said yesterday that Mr. Zuma has brought so many applications for over a period of 20 years. So he's familiar with the court process. Right? He is one of the most reported litigants in this country. And the media has not been very kind to Mr. Zuma. But because he fought for them so that they could have this freedom to report on whatever they want to report, he walks away. He laughs sometimes. He takes it by the chin. And life goes on. But you breach a law, Section 41(6), as a journalist. you try and hide on manufactured facts, and you try and hide behind Section 16. That's an irresponsible response to a Section 41.6 charge. It's a false response. It's not born out of facts. It's not born out of evidence. This is not a case in which a private prosecution is attacking the media or is attacking Ms. Mon. Ms. Mon is caught in the factual narrative of the facts which Mr. Mpofu will deal with. If you confine this story to the facts, you will not see the relevance of Section 16, because this had nothing to do with Section 16. So when they say as the media, that the prosecution or that the private prosecution is aimed at using, I beg your pardon.
I'm hearing some strange sounds emanating from my lips. Has someone got a cell phone on or something? It's like music or something that's coming through you now. Please, I will ask you for the last time, ensure that your cell phones are switched off. Sorry, Mr.
No, it's so the interest of the media in this, the media are making in this application is entirely partisan, entirely antagonistic of Mr. Zuma. They essentially caricature. They seek to devalue the dignity of Mr. Zuma by suggesting that he is an enemy of the media. So they are here saying protect media freedom on manufactured facts. The true facts of how Ms. Mon came to become an accused person in the private prosecution have nothing to do with how she reported in any of her reports. Nothing to do with it. So it's not true that this private prosecution is by a person with power who seeks to stifle dissent and criticism. It's not true that this case of the private prosecution is an example of how the law, including our courts, can be rendered at risk of being used as a tool by persons with power to stifle dissent and criticism. At the risk of repeating this, there is not a cent of evidence, not an iota of evidence that this private prosecution has affected the media, its ability to report, or even its safety. There's not a single point of evidence that the media amici could give which support their contention. I mean, they give us obviously reports, but those reports don't reflect South African reality. Many South Africans would not quibble with the proposition which the media amici makes, which is that courts can be used by a powerful person in society to stifle dissent and criticism. We are all too aware of how courts were used by the apartheid government to stifle dissent, to stifle criticism. Mr. Zuma was a victim of that. Mr. Zuma went to jail because of the system of law and courts that were used by the apartheid system and its machinery in order to stifle dissent. They basically didn't want him to speak and to disagree with the system of apartheid. So we're familiar with that principle. But it is absolutely an irresponsible accusation to suggest that Mr. Zuma has triggered this private prosecution because he wishes to stifle dissent, when there is absolutely no evidence of that. The evidence of the apartheid system is there. Mr. Zuma is the evidence. He was in jail for 10 years because he had something to say about the apartheid system, which the apartheid government didn't like. So they arrested him and they put him in jail. Well, I don't want to say what happens after independence or after the constitutional democracy, but he's been to jail again during his the period of this constitutional democracy. Let me deal with the slap defense or the slap plea. The media that's a refreshing sort of argument they seek to present. So to their credit, would accept that the idea of trying to extend the SLAP theory or the SLAP doctrine to cover criminal cases is a novel one. How it works, we don't know. What its attributes are, we don't know. They have not told us. But here is the problem. The SLAP means strategic lawsuits against public participation. Strategic lawsuits against public participation. It's not very clear how this private prosecution should be regarded as a SLAP suit. It's not clear on what legal principles, other than the already existing one, which is the doctrine of abuse of process, that the SLAP doctrine will assist the courts. But let me immediately deal with that, because even if we were to say, for good measure, do extend the SLAP doctrine to cover criminal prosecutions. Firstly, remember that their motivation is obviously mercenary, in the sense that their main target is Mr. Zuma. But let's accept that the court in its evaluation decides, well, it's attractive to bring in a doctrine from the United States, a big power, and it's got a big brain, and perhaps we learn something from it in terms of how we do our criminal cases. This SLAP suit will affect both prosecutions by Mr. Downer and his friends, the other prosecutors he's sitting with. It will also affect private prosecutors like Mr. Zuma. So it will affect both private and public prosecution. It's not going to discriminate. So Mr. Zuma notionally can raise SLAP defense in the criminal prosecution that Mr. Downer is pursuing against Mr. Zuma. Right. So you will have the SLAP.
I just want to correct you. The state is pursuing the prosecution, not Mr. Downer.
Mr. Downer is the prosecutor.
There's a distinction.
Yes. No, that's fair enough. But Mr. Downer is the prosecutor. That's all I want to emphasize.
We are not debating that issue with you. We're just really correcting your error.
Yes, and I'm clarifying what I actually intended to say.
We don't need to go further with that. We've corrected you, accepted, and let's move on.
So Mr. Downer as the prosecutor of Mr. Zuma would be affected, because they would have to deal with a plea by Mr. Zuma based on the SLAP defense at some point. Now, if you were to admit this SLAP type defense into our criminal law, according to the mineral science resources case, which was referred to by my learned friend for the media amici, I would invite the court to go to paragraph 96 of that case. And you will see that what the court says there is that towards the so the court says it can 96 in the middle. It says it can conceivably accommodate the SLAP type of defense pleaded by the defendants. Plainly, in the present instance, the defendants will have to prove, and this is key, at trial. This is very important. The defendants will have to prove at trial that the defamation suit brought by the plaintiffs is an abuse of process of court, is not brought to vindicate a right, amounts to the use of court process to achieve an improper end, and the use of litigation to cause the defendants financial or prejudice in order to silence them, and violates or is likely to violate the right to freedom of expression entrenched in Section 16 of the Constitution in a material way. But this is done at trial. So if you were to extend this SLAP defense to criminal proceedings, this SLAP defense would have to be raised at trial in a criminal court, not in these proceedings. It would have to be raised as a special plea, would have to be raised by the accused person, and evidence would have to be admitted by the complainant of the prosecution. So that is the first thing. It would have to apply to both criminal. Sorry, it would have to apply to all criminal cases, whether being private or public prosecution. Secondly, it must be raised at trial. Thirdly, it must be raised by the accused person at trial, and the accused person will have an onus to prove certain things about that particular slap defense. So we have no difficulty if the court should find that there's wisdom in extending the slap theory into criminal proceedings. Mr. Zuma would essentially be one of the beneficiaries of that, and I'm sure that if that were to be the case, then obviously we have a long way to go. Yeah, we might consider amending our plea and bringing the slap defense. So we would have a very long way to go. But we suggest that introducing this plea would create a difficult procedural element. Would introduce a difficult plea and introduce a difficult procedure within the criminal process, because the state will have to wait a little bit from pursuing a prosecution. Firstly, deal with this slap suit as its own, run the evidence there, defend it, do whatever. So it introduces further pleas that may be dilatory in the achievement of a criminal prosecution that is expeditious and fair and free. But I mean, the slap theory is really strategic litigation against public participation. I mean, one wonders what actually the public participation component of that theory would be in a criminal prosecution. So there is no case in South Africa that we are aware of, criminal case that we are aware of, where the slap defense was raised. And so even the motivation for the introduction of the slap defense, it's false. There's no evidence whatsoever. You heard from the media amici that there is a growing trend of attacks on journalists for doing their work to justify the employment of the slap doctrine. A growing trend against us. In South Africa, we don't have a single criminal prosecution in which the prosecution had to deal with the slap defense. So it's not clear why these facts are here, because there is no evidence whatsoever. They can get evidence elsewhere, but the evidence relevant is evidence here in South Africa. And so we say that it's wrong for the media to suggest that there is a growing attack on them, and the available defenses to them are not good enough to stop these attacks. That you would need to have a slap plea in order to get your way to defend yourself against a prosecution. So we would say that the extension of the slap doctrine into criminal law would certainly be novel, but it certainly will not make it easier for both private and public prosecutors to conduct their criminal prosecutions in the manner in which the Criminal Procedure Act says they should. So there's the supporting facts there is that there is a growing trend of attacks on journalists. The evidence in this court is that a single journalist faces private prosecution through the window of that single journalist, they want you to introduce a plea in the criminal process that will basically introduce a new terrain for criminal prosecutors. There is no factual justification for it, but even if you were to find that it's an attractive doctrine to extend to criminal proceedings, we say you mind the difficulties that you are making for the criminal prosecutors, public criminal prosecutors, and for the state and the individual or private citizens who wish to prosecute. Then there is a theme that runs through both Helen Suzman Foundation and the media. I've dealt with the media. They have no evidence whatsoever to suggest that Mr. Zuma said somewhere and manufactures this private prosecution in order to stifle dissent or to stop Ms. Mon from being the exceptional reporter that she is. No single evidence whatsoever of that. Now, the Helen Suzman Foundation says, look at Mr. Zuma's conduct of the private prosecution. Extract from that conduct whatever you can extract, and infer, you will find a good inference, an inescapable inference, that this prosecution has not been activated against Mr. Downer and Ms. Mon for legitimate prosecutorial reasons, legitimate purposes. But it is in Helen Suzman's extraordinary attacks on Mr. Zuma, it is to pursue a political agenda. They don't say what that political agenda is, by the way. They just throw politics in it. They just throw insults and epithets that are very unkind to Mr. Zuma, but not true, not supported by evidence. So the notion that a private prosecution of a crime that exists on the facts that we have can reasonably lead to the conclusion of ulterior motives. Absurd. It's completely absurd. But it's consistent with their position that Mr. Zuma is after the constitutional system in prosecuting one prosecutor for a crime that exists. Honorable Court, let me just deal with the submissions made on Section 41(6) and how the interpretation of that provision should be approached. Clearly, the attempt of the media is to interpret Section 41(6) in a manner that exempts journalists from prosecution for a breach of that law. But we all know that would violate Section 9(1), which is what Mr. Ngalwana for the Democracy in Action said. The purpose of Section 41(6) of the NPA is to ensure the integrity of the prosecutors of the office of the National Director of Public Prosecution, of the National Prosecuting Authority, to ensure that the information they have, on which they rely to conduct their work, does not lead to the prejudice of people that are implicated in that information. So it's a valid purpose. No one can quibble with the purpose for saying to prosecutors, information you get while you are performing your functions must be held in strictest of confidence. The media amici says, if the law is interpreted as we believe it should be, that would not protect journalists from the reach. That would not protect journalists from criminal prosecution for violating the law. But I've already, relying on the principles of Ndumeni, the famous case on statutory interpretation, it's clear that the interpretation they seek to advance is untenable. Interpreting a law in a manner that would essentially discriminate people would be wrong. on the discriminate them on the basis of calling or profession or whatever whatever else is. But here is another false submission or inaccurate submission. It is that Section 41(6) implicates the right of free speech in Section 16 of the Constitution. I've already mentioned that Section 41(6) does no such thing. Section 141(6) prohibits the disclosure of information without authorization. So it does not per se prohibit disclosure of information. You must just get the permission from the National Director of Public Prosecution or the assigned, the delegated functionary by that office. The media amici do not tell us that it is difficult to get that permission, or getting that permission would impose an unconstitutional barrier on the freedom to report on information that they get. They don't tell us those kind of nuances. So the 41(6) argument falls away. It has nothing to do with Section 16 because it does not prohibit the freedom of speech, or sorry, the freedoms under Section 16. It merely says to journalists who want to report on information obtained by the information obtained from the NPA, please get the permission of the National Director of Public Prosecution before you can publish this information. Once you get that, that's where your protection is. We sort of reserved fairly harsh terms for Helen Suzman Foundation for a good reason. And it is no exaggeration that their submissions, their conduct as amici essentially is an abuse of the status of friends of the court. This is one case where words are just used carelessly without any thinking, but you can see that perhaps I'm guilty of that myself, but mercifully, I can quote from what they say in their founding affidavit. I'd invite the court to look at the founding affidavit, to look at what they say about Mr. Zuma and the private prosecution. They say that Mr. Zuma's prosecution of Mr. Downer is an explicit attempt to undermine the criminal justice system.
So, what's affidavit?
I beg your pardon?
What's affidavit?
The affidavit of Ms. Fritz of the Helen Suzman Foundation. They say it's an explicit. No, they don't even say it's implicit or something softer than anything. They say this is the clearest attempt to undermine criminal justice system. That's sedition. That's serious stuff. For someone who has served time in jail for contempt of court to be accused of undermining criminal justice, this is propaganda. This is not responsible exercise of a friend of the court, and the court should dissociate itself from such a friend. They say that he does not come to this court seeking adjudicative determination of the so-called criminality of Mr. Downer's conduct. They say he comes to court in bad faith and for an ulterior motive to pursue political ends and accountability, none of which is supported by evidence. There is no evidence of what these political ends are. What is the accountability he is seeking to avoid? So here is the problem. By an organization that stands for human rights, making these kind of arguments. Mr. Zuma is being prosecuted. Mr. Zuma's prosecution by the state is conducted by Mr. Downer. What Helen Suzman Foundation says is that if a prosecutor commits a crime in the course of conducting a prosecution of an accused, the accused has no remedy. But if the accused person should seek to prosecute the prosecutor for committing a crime, that is an ulterior purpose, a bad faith, and it's an attempt to avoid accountability and to dabble in politics. Mr. Zuma has no political interest in pursuing Mr. Downer, except that Mr. Downer, in the course of conducting his work as a prosecutor for the state, did some things that Mr. Zuma believes violate the law. Here is another false statement by the Helen Suzman Foundation. They say Mr. Zuma takes aim at the NPA itself. That's false. Prosecuting Mr. Downer is not taking aim at the National Prosecuting Authority. It's inflammatory, it's not borne by evidence, it's simply an irresponsible statement that is conjured up by somebody who an entity that comes to court pretending to be a friend of the court, when in fact it's an enemy of one of the parties. I've already said that they consider Mr. Zuma's prosecution as a game, and they say he intends to pursue a sham. You can't have friends like those, honorable justices. You cannot have a friend who speaks like this about a party who seeks justice before you. It's wrong. They should come out clearly and say who they support, which they do, by the way. But then they seek the gaps of a friend of the court to make these kind of inflammatory statements, which are not born out of the facts. What the Helen Suzman Foundation does not do is to take the entire factual matrix. They say, like Mr. Downer, take the 19 years, or the so-called 19 years of Mr. Zuma's criminal prosecution, and they say Mr. Zuma has engaged in all sorts of things to avoid his prosecution. But that's not true. Firstly, it was the NPA which stopped the prosecution right at the beginning. Mr. Ngoga said, no, we're not going to prosecute Mr. Zuma. But here they are saying 19 years Mr. Zuma has been trying to avoid prosecution. It was the NPA which ended up in court being told by the Supreme Court of Appeal and another court in the Gauteng full division that they must prosecute Mr. Zuma, or at least they must relook at their decision to withdraw the prosecution. Because as you recall, it was the NPA on its own words that said there is evidence of political machinations and political interference in Mr. Zuma's prosecution. And prosecutors who were senior to Mr. Downer said it's unconscionable. We cannot activate the process of prosecution against Mr. Zuma in light of the evidence we have. It's on oath in the affidavit of Mr. Hofmeyer. They are here, the Helen Suzman Foundation, picking up facts that suit their narrative, abusing the position of being amicus curiae. They say Mr. Zuma seeks to avoid accountability. But they don't tell us what accountability he seeks to avoid. Mr. Zuma is in court, exercising a lawful prosecution. What accountability is he trying to avoid? Criminal prosecution. He has pleaded. The criminal prosecution is going on. So it's a false statement that Mr. Zuma seeks to avoid accountability. In fact, it sounds very familiar in political circles than in legal circles. You can't have a friend like that. They say that if this prosecution is allowed, it would be a debasement of our criminal justice system. But they don't tell you why it would be a debasement. I mean, the word debasement is like, you know, this would be really hit at the pit of the core of the integrity of the prosecution. But they don't engage with the facts in order to come to these extraordinary statements. They say that Mr. Private Prosecution is here to achieve a purely political objective. Now, when you say political objective is one thing, but when you say purely political objective is another. So you must then give evidence of what this pure political objective is. There is none. So this is an extravagant statement made by an organization that is respected for protecting the rights of people. They are not overwhelmed or even shocked by the prospect that the NPA as a state organ has abused its own power against Mr. Zuma. Well, if they appreciated the entirety of the facts, but they pick facts which suit their political narrative as an organization. They say that the role that this private prosecution plays in Mr. Zuma's effort to avoid accountability in a system governed by the rule of law. Again, that's another extravagant statement that Mr. Zuma's prosecution undermines the rule of law. But they don't tell you in what way. They don't say that Section 41(6) is unlawful. They don't say prosecution under Section 146 is unlawful. Or in fact, step back. They don't say private prosecution is unlawful. They accept private prosecution is unlawful. But here they are saying that Mr. Zuma seeks to avoid in a system governed by the rule of law. Rule of law includes private prosecution. So Mr. Zuma is sliding bang right there in the middle of the rule of law doctrine. They forget very obvious facts which should not be easy for an organization of the nature that we are dealing with. Obvious facts. If you look at the 19 years that they accuse Mr. Zuma of playing dilatory tactics, former public protector Mshwana said the NPA had acted unfairly against Mr. Zuma. Never been reviewed, stands as a finding of an entity like that. Judge Msimang had some choice words to say about the NPA's conduct. They don't remember those facts. They don't also reflect what, although it was overturned by Nicholson, by the Supreme Court of Appeal, what Judge Nicholson's judgment says about the NPA. Judicial officer, significant standing, his views matter. They don't reflect a little bit as an organization that is interested in pursuing rule of law and being fair to a litigant. They come to court wearing garbs of a friend, but in fact seek to poison the atmosphere of fairness. They seek to load it against Mr. Zuma. So simply put, the Helen Suzman Foundation appear to be an additional advocate for Mr. Downer. So they support the extensive narrative propagated by the NPA that Mr. Zuma seeks to escape justice by adopting, as Mr. Butler says, meritless applications. It's a cause for concern for an organization of this nature that says we're a human rights organization to not be concerned about what Mshe said about the prosecution, what they discovered when they investigated what had happened in the prosecution of Mr. Zuma by an entity with so much power. So the Media Amici and the Helen Suzman Foundation, regrettably, are not the friends of this court. They are rather additional advocates for the applicant accused, Mr. Downer and Ms. Mon. Then the last point that I'll deal with is the allegation by Helen Suzman Foundation that somehow this private prosecution implicates prosecutorial independence. Perhaps the less said about it, the better. Because private prosecution as a system of our law, as an acceptable legal instrument for prosecution, per se cannot undermine prosecutorial independence. That's the first point. But take that a little further. Mr. Zuma's prosecution, if they had bothered to look at the facts, the true facts of why Mr. Down is an accused, they would not come to this irresponsible conclusion that somehow a private prosecution undermines prosecutorial independence. I mean, you're all too aware of prosecutors. Prosecutors are subject to a heavy regulatory regime. Their conduct is heavily controlled. They have got a code of conduct. They've got the National Director of the National Prosecuting Act imposing very strict legal requirements for their conduct. So it's not clear. In fact, it's not quite clear. There is no basis, no factual basis on which the Helen Suzman Foundation can support this extraordinary, very vague, unsupported notion that somehow you must find prosecutorial independence being affected. And it's simple. What is extraordinary about this case is not that a prosecutor is being prosecuted by the accused person. That's not extraordinary. What is extraordinary, and that should be of concern to an organization like Helen Suzman Foundation, is that a prosecutor, while conducting a prosecution, commits a crime that implicates the dignity of the accused person. That is extraordinary. And that, by law, is wrong. The Code of Conduct says it's wrong. The law says it's wrong. And so there is no prosecutorial independence whatsoever that is implicated. So we say that, sadly, these attacks on Mr. Zuma are not only unfair, and when you assess what these submissions made by the Ameki, we urge you to look at whether or not they've created for you an atmosphere of fairness, independence, impartial application to your mind on the real dispute that is before this court. And you will come to the conclusion that the Ameki came with their own facts, which were not supported at all by evidence. That is why, in a moment of reflecting on these issues, we thought the court should examine, even though, and it's a principle that is acceptable in governing friends of the court, that a court, even if you admitted them as a Ameki, these are the same arguments we would make if we were to go further. And the court further might say they shouldn't have been admitted. But you are at large as this court to say we admitted them on consent by the parties, but we retain a continuous oversight over the conduct of Amicus Curiae. We are entitled to look at their conduct, to look at their submissions, and to see whether or not they enhance our independence, they enhance our dignity, they enhance our impartiality. And if we should find that they don't, then we must disregard their submissions. Those honorable justices would be the submissions of Mr. Zuma in response to Ameki. Can I just take a view from? Is there anything I need to say? Those are the submissions. Thank you.
This is Malaya from Ms. Hofmeyer wishes to address the court.
Thank you, my lord and my ladies. My lord and my ladies, you'll recall that when I addressed the court on Monday, I indicated that if there was going to be an argument from Mr. Zuma's counsel on the very aspect that has been addressed today, I would seek leave to address it. It's the question of whether, consequent upon admitting Ameki to these proceedings, arguments about whether they should have been admitted and whether they are friends of the court can even be entertained at this stage of the proceedings. I would like to address the court on that aspect. It's a critically important aspect for your adjudication of this matter and what you make of the amici submissions. And I would at this point just seek a direction as to when the court would best like us to address that aspect, assuming leave for us to do so is granted. Thank you, my lord. And just to be clear, I did not interject when my learned friend, Mr. Mpofu, spoke about the time allocation today because I wanted to see how the argument had progressed. We hadn't had a discussion about accommodating some time for the amici, and we simply say it's necessary because of the manner in which the argument has been presented. Thank you.
I'm sure everyone, by everyone I'm speaking specifically to counsel who are going to be presenting the argument are aware of what happens.
Indeed, my lord. Thank you.
As the court pleases, my lord and my ladies, maybe I should actually just quickly deal with that issue. And I'm glad that the court has dealt with it in that fashion. We, of course, do not will oppose any attempt by the amici to get a second bite at the cherry, which they are not entitled to. However, we do accept that my learned friend Ms. Hofmeyer had raised the issue of admission or no admission of the amici. And I simply want to say this, which may hopefully allay her fears and not even make it necessary for her to address the court. And Mr. Masuku, my learned friend Mr. Masuku, made this very clear, but in case it was not heard properly by Ms. Hofmeyer, we do not seek to contest the fact that the amici have been admitted. That would be foolhardy, because we are the people who consented to that in order to save this court unnecessary waste of time and debates and having to do a separate judgment on the amici and all that, because we want to get, contrary to popular belief, we want to get on with the real issue, and that's why we consented. So there is no submission which is made by Mr. Masuku or me which undoes that. All what Mr. Masuku is saying is that the amici, having been admitted and having been given an opportunity correctly to address the court, one cannot then take away our right, or Mr. Masuku's right, or more appropriately former President Zuma's right, to say that these particular submissions of these amici who are here rightfully in front of you are presented in such a way that the court must be very cautious to embrace them as being part of the friends of the court. Now that happened in the outer case, it happened in various other cases where the real submission is this, really, to cut it short. If a party seeks to play a partisan role in the litigation, which is allowed, it's a free country, Section 34 of the Constitution allows it, all that party needs to do is to proceed in terms of Rule 12 of the Uniform Rules of Court and ask to be joined as a party. That's all. That was the thrust of what Musenega DCJ said in Outer. But to masquerade as a friend of the court and then come and take the cudgels on behalf of one of the parties is something that the courts must be wary of. That's all we're saying. We're not contesting their admission or non-admission. Yeah. Thank you. Yes. Thank you. So there's no need to be concerned about the admission or non-admission. Right. Okay. So let's start then with the more serious business of the challenges before this court. Maybe I should just start by signposting so that the court can know where I'm going. I'm going to start for a few minutes just to round off some of the issues that Mr. Masuku raised. And in fact, the one about Rule 12, I've already made that point because it's a point I wanted to emphasize. That's fine. But for continuity, I'll start from where he left off and then link into my main argument. Now, as far as the argument itself is concerned, I'm going to do this in line with the approach that we took in our heads of argument of effectively submitting for the convenience of the court again one set of heads. I will follow that approach. But in doing so, there is obviously, there are overlaps. There are certain areas where both parties make the same point. Section 7.1, ulterior motive, what have you. And then there are areas which can only be ascribed to one of the accused or the applicants. For example, the issue of the nolle prosequi. That is only raised for obvious reasons by Ms. Bond. And Mr. Dana doesn't raise the point because the nolle prosequi mentions his name. So when I'm dealing with an issue that deals specifically with Ms. Bond, I will so indicate. But generally, I will start by dealing with the issues that covers both the common areas of overlap. Right? Then, if it pleases the court, I will then deal squarely with the bifurcated or let's say the separated nature of our argument, which is the points in limine on the one hand and the merits. Contrary to the extravagant submission made on behalf of Mr. Downer, which says that we do not address the merits, I will demonstrate that nothing could be further from the truth. At every stage where we say, for example, the court has no jurisdiction or whatever, which is the points in limine, we then go on to say in any event, and assuming the court does have jurisdiction, then we deal with the merits. The entire section D of the MON answering affidavit by former President Zuma deals with the merits. Once we've dealt with even our heads from about page 21 onwards, the heads deal with the merits. So to suggest, as was said here, that all we did, we said, no, don't worry, here are the issues on the points in limine. And then as far as the merits are concerned, it will deal with it in the criminal trial. That's a direct and a deliberate misrepresentation of what we are saying. We do say that some of the issues must be dealt with in the criminal trial, and I'll explain why we do so. But every time we say that, we then say in any event, and then we deal with that issue and dispose of it, whether it's Stalingrad or ulterior motive or the Sandral issue and so on. In fact, the Sandral case, we even cite it in the affidavit, let alone in argument. So I'll make that separation so that anybody in this room must be clear that we separate, as we all do, between the points in limine and the merits. Then I'll deal with questions of costs, and then with some of the authorities, well, that will be infused. So that's the layout. But by way of preface, let me say this. This case, the significance of this case is far more than what meets the eye. This is a case about human rights, about so many things that are wrong in this country. It's a very significant case, and we don't know where it will end up, but hopefully it will clear the air on very many issues which might at face value not appear to the naked eye right now. Why do I say that? Because everybody is starting from the wrong point. My learned friends, Mr. Badlander, okay, I'll call him Mr. Badlander Senior. I don't like calling him Mr. Badlander Senior or Junior because that it might seem to be condescending to Mr. Stephen Badlander.
I'm used to it.
He's used to it for all his life, he says. And but so now and again I'll call Mr. Badlander, the first Mr. Badlander. Fortunately, the elder Mr. Badlander X for choose number 1, so he'll be Mr. Badlander number 1, and Mr. Badlander number 2. But if I slip back to Mr. Badlander Junior or Senior, I mean no disrespect to my learned friend. But fortunately, for the purposes of this submission, I don't need to make that discrimination, because both of them, my learned friends, none of them, it was remarkable to me, not one of them read out the section 41(6) of the NPA Act, which is why we're here. The first time that section was mentioned was by my learned friend, Ms. Hofmeyr, in a different context. But that's where we must start. That's where we must start. I'll come to the section. Because the only thing that brings former President Zuma here is that one day, on the 21st of October 2021, he went to a police station down the road somewhere here and laid a charge of, in terms of section 41(6) of the NPA Act, read with 41(7). That's why we're here. That's the only other. If he hadn't done that, if he had decided on the 21st of October to just sit at home, we wouldn't be sitting here. So that's the most important thing. What is this section? What is it about? What does it seek to cure? What is the mischief that the legislator had in mind when it enacted section 41(6) and 41(7) in particular? Because that's another thing, little thing that gets forgotten. Why did the legislator feel that this offense must be punishable by 15 years imprisonment? 15. Not 6 months, not 2 years, not 3 years, 15. A long time indeed. Why? And why did nobody at that time say, no, this is now overkill? I mean, just for disclosing information, which you might do maybe, in a moment of weakness, sitting in some tavern or whatever. 15 years. And I will take this court and explain why our legislature took what to the naked eye might look like a harsh consequence for this offense. This is no game, as my learned friend Mr. Masuku explained. This is no game by any stretch of the imagination. We're dealing here with one of the most egregious crimes ever invented by our legislature. Sometimes even murderers get less than 15 years. But let's put that aside for now. It was remarkable that the section itself was not referred to. In fact, for that reason, because of that, the section was then misrepresented in all sorts of ways. But if the court allows me just 5 minutes, really to step back for context. But learned friend Mr. Badlander, for the first applicant, for the first accused, or the applicant in the first in the Downer matter, for Mr. Downer, says that Mr. Downer is not here to assert any constitutional right. And that's why he says, well, he doesn't understand why we talk about subsidiarity and all that. Fair enough. Well, he might not be here to assert any constitutional right, but let me tell you one thing. Former President Zuma is here to assert his constitutional right. And that right is simply to be found in Section 34 of our Constitution, which entitles every citizen, even former President Zuma, to bring to a court of law any dispute that can be resolved, I'm paraphrasing, by the application of law. Any court of law, whether it's this court or the criminal court or whatever, or the labor court, for the purposes of that submission, doesn't matter. That's why we're here, at least speaking for ourselves. And what has that got to do with the Constitution? What is this thing called private prosecution? You know, some students from UNISA jokingly said to me, now you've started this private prosecution. When we do criminal procedure, everybody just went through it because you knew that there would be no question asked about it because it's so rare. But now we have brought it into the public domain, as it were. Well, for the education of those who don't know, a private prosecution is not any game. It is probably one of the cleverest inventions of any legal system. You'll find in Du Toit, because of time I won't go through it, but there's a section on private prosecutions that goes back to, you'll find it in the very opening part of the book. I think it's 1-3 of this book. And it says, when individuals relinquished to the state their right to private vengeance, they did so on the tacit understanding that the state would dutifully prosecute crime. And then it goes on. I'll just paraphrase. So the very institution of private prosecution is meant to inhibit us from our natural instincts to hit back. An eye for an eye. So you take in that example, former President Zuma is supposed to say, what? You take my medical information, you take information that belongs to me, you leak it to the media without my permission, or at least as the law prescribes, without the permission of the NDPP. When we report that to him, he's supposed to say, where are those people? I want them here now. I'm going to show them. Where do they live? And seek private vengeance and go and do whatever he thinks will ameliorate that injury to him. But no, the law and our forefathers had a better idea. They said, no, former President Zuma, you don't have to do that. First, you must go to the police station in Maritzburg, which he did, and lay a charge. And the state will then, on your behalf, take over that anger that you have and do with it what the law says it should be done. And then you should be fine. It was the wisdom of the ancient. But it goes further. It says, but former President Zuma, in the event that the state refuses, for whatever reason, good or bad, to then act on your anger, you have a conduit called private prosecution through which you now may prosecute. So still don't go and beat up the people or whatever. You should... well, my lord, it might be well known to this court, my lord, but I'm not only addressing this court. This is that's what I'm saying. This matter is the context is very important. Yes. Yes. Okay. But that's fine. Well, okay. Well, then it means we are in the area that we were fearing. Yeah. That's fine. Okay. Where am I going with this? Let's go to section 41.6 now that the court understands the purpose. Because we are told, in fact, the court is, or let me just say, the impatience with the context is unfortunate, because what Ndumeni tells us is that we must, when we are interpreting section 41.6, look at the context. And not only look at the context, look at the purpose. That's what we call purposive interpretation. So if we are not to canvass the purpose of section 41.6 in the context of this case, that's fine. But let's at least, or even the purpose of section 7 of the CPA, which allows for private prosecutions. That's also fine. But what I've already said covers some of the purpose. But it's impossible. Let me just say this for the record, so that I'm never misunderstood on this. It is impossible to adjudicate this case, at least this one, in front of this court, without taking a purposive and contextual interpretation of section 7 of the CPA on the one hand, or section 41.6 of the NPA Act. It's impossible. And the reason why the Constitutional Court and the SCA favors this contextual and purposive interpretation is because otherwise everyone can just come in here and say, okay, let's look at the mechanics. Section this and A and B and C and D and B's and what, without understanding what really we're here about. But that's fine. Now let's go then to section 41.6. Or let me pack that. I'll tell you, my ladies and my lord, where we're going to find some of these things in the papers. These papers are difficult to navigate because there's the Downer volumes and the Karen-Mon volumes. But I'll try to, as much as possible, to guide the court. Now, unfortunately, I have to go back again to the issues of context, because I'm now going to address the preliminary points. The first preliminary point we raise, of course, is a matter of jurisdiction. And then the second point that we raise, which is related to that, is prematurity or ripeness. Call it what you will. And then we raise the issue of only in respect of Mr. Downer, the authority of the state attorney to act, and then the joinder or non-joinder point in relation to the non-joinder of Ms. Mon. But the big points are the first two. Jurisdiction in this context is very important, because once again, why are we here? in the civil court, in the civil motion court, in front of 3 judges. Those 3 things are important. We're in the civil court, we're in the motion court, and we're in front of 3 judges. To do what? To determine a matter that belongs and is actually running in the criminal court next door, quote unquote. Ironically, it's actually not even next door, it's in this court, this very court. And one of your brothers or sisters will hear this matter in this court or continue to hear it wearing red robes, not the black robes that your lordships are wearing today. Why? That's another issue. I know we don't want to go to context, but it's another issue that needs to be taken seriously. People don't know that it's not a fashion statement that a judge in a criminal court wears red robes and the judge in the civil court wears black robes. It symbolizes the distinction between the 2 courts. In England, there's something called the Old Bailey, which is where the red robes sit, and then other places where other people sit. So it's even different buildings. Why is that? Because the constitutional founders, in their wisdom, decided that criminal matters must be decided in the criminal courts and civil matters in the civil courts. And at the risk of telling the court what it already knows, even for the sake of context. That distinction is not contrary to what was said in the President of the Republic of South Africa case versus Mr. Zuma. That distinction is very serious. You can't just say a court is a court. No, it doesn't work like that. And that is why in the criminal court, for example, if this matter had been raised in the criminal court where it should be, there is no possibility whatsoever that you could have it heard by 3 judges. Because criminal trials, as we know, are heard by 1 judge wearing red. For a good reason. And that's where the rub is. Is it permissible? Should it be allowed in our system that you have a criminal matter and then you say, no, just wait a little bit, my lord. I'm just going next door to the civil court to ask them to set aside this prosecution. I'll come back. I'll see you later. Imagine if all accused could do that. There'd be chaos in this country. Every not Monday, every day, there are thousands and thousands of people appearing in criminal court. If they all one day said, if you can say this, go and tell this to the awaiting prisoners, they'll say this is the greatest news we've ever had. That we can actually stop this magistrate or judge and go to the urgent court, Nafal, and stop what is happening there. It's bizarre. So the first thing is that the criminal matters should be heard in the criminal courts. And if you don't believe me, then you can at least believe His Lordship Mr. Justice Wallace, who said the following, Wallace J.A., I'm sorry, who said the following in the Moyo case that your Lordships have. Let's start at paragraph 169. Yes, no, let's start at 157, I'm sorry. 157, your lordships will be familiar with that case. The facts, I'm not going to traverse them to save time. He said, and this is where the subsidiarity point, which was completely misunderstood, start. He says, the appellants do not seek to impugn the provisions of the CPA, Criminal Procedure Act, in any way. They are seeking to assert their fair trial rights before a civil court, as happens here. That should give pause for thought. Why are issues germane only in the context of criminal proceedings being canvassed and determined in civil proceedings, and not in the constitutionally compliant forum and in accordance with the constitutionally compliant statute provided for the adjudication of criminal cases? He asks us as a rhetorical question, because he then goes to answer it. But let's mark just the rhetorical. He says it must cause a pause for thought. Why are issues coming from criminal context being adjudicated in civil proceedings, where the legislature of this country has determined that it should be in the criminal court? And when you are not attacking the constitutionality of the CPA, then you are forced to apply that statute. That's what subsidiarity means. If you are not, unless if you are attacking the constitutionality of the Criminal Procedure Act, then you must abide by it, whether you like it or not. If you don't like it, then you must attack its constitutionality. And he says, the appellant's response to this question is to say the Constitutional Court has held in Savoy that they have standing to bring the present proceedings. Savoy involved confirmation proceedings where the Constitutional Court was obliged to accept jurisdiction. So that shows that this is a jurisdiction point. And then he says at 158 further down, the concern in this case is that it has been done outside. I'm sorry. He says here, at an appropriate stage and in appropriate proceedings. Please underline that. At an appropriate stage and in appropriate proceedings, because that is going to arrive when we talk about prematurity and all that. Which is the only place where the constitutionality of legislation is an issue. It is an abstract challenge, and as Madlanga J. rightly said in paragraph 13, courts generally and rightly treat abstract challenges with disfavor. Again, it's just another fancy tag, abstract challenge. It simply means challenging something, effectively challenging something's constitutionality, but without attacking the actual constitutionality of the, outside of the Hande case, which I'm sure the court knows about interpretation. Yes. Then he says at 169, which is really what we have here. The trial has not commenced in that case. It is commonplace to see in the media that the first step in any criminal proceeding, in any criminal litigation involving a prominent person, is that they will challenge the constitutionality of the charge or the process leading up to the commencement of criminal proceedings, which is what's happening here. The term Stalingrad defense has become a term of art in the armory of criminal defense lawyers. And then here's the rub. It says, by allowing criminal trials to be postponed pending approaches to the civil courts, justice is delayed and the speedy trials for which the Constitution provides do not take place. I need hardly add that this is of particular benefit to those who are well-resourced and able to secure the services of the best lawyers. And then he says that all of this, the question in every case, I'm at 170, is one of the interests of justice. That's really the test that you must apply. In my view, the interests of justice in both of these cases demanded that the High Court decline to hear them before the resolution of the criminal trials. And his lordship basically was saying, to paraphrase, that courts should not hear these types of matters unless if there are exceptional circumstances. And we've made the point numerously in our heads that no exceptional circumstances have been pleaded here, or it has not been shown any, the interest of justice is not even mentioned, which is the only test really. So the court cannot just on its own invent the interest of justice when the people who have brought the case here have not asserted it. And actually one of them has said he's not here to assert any constitutional rights. The tea. How long? Yeah.
Yeah, nami move over. Yakubona izikonile ziyazi ukuthi kuyapi. Ngibona isisheshe zakubamba. Anasana ukufrustana, sicabanga ukuthi mina ngithunyiwe. Awubazi ngani? Oh, bathi immediate 24. Bangibonile. Ubonile ukuthi bathi kumele babheke ukuthi ukhuluma ngayo le time. Athi mina ngimazi nami. Akunasiki. Oh, ile. Mawufakele mic. Bathi hayi. Bafuna bengathi already sebayazi ukuthi. Sebakubonile bayazi. Man, mina
Thank you, my ladies and my lord. I will proceed with the point that I was making before the break, and for the sake of time, I'll interpose it with the prematurity point. As I said, those 2 points are really two sides of the same coin. In a nutshell, what we are submitting really is that in the first instance, the court that has jurisdiction is the criminal court, but in the second instance, that even in the criminal court, these issues should be raised at a particular stage. So the court, again, will be familiar, and I'm assuming that it is, with the provisions of Section 106, 1H, but I have to make these submissions nevertheless. That 106, 1H is known as a special plea. There's a reason why it's called a special plea. A special plea has the same meaning whether it's in criminal proceedings or civil proceedings. It means it's a plea that has to be raised in a way to avoid the going through the unnecessary expense of a long trial and so on, which is the point that my learned friend Mr. Badlander for Mr. Downer was making. But that even a 106.1H plea for title to prosecute cannot just be raised at any stage. That section says that it must be raised when the stage for pleading comes. We all know how a criminal trial runs. You have the arraignment, and the start of the criminal proceedings is when you plead. Or rather, the start of the trial is when you plead guilty or not guilty and so on. And it is at that stage that a 106.1H plea is raised. Never before. It can't be raised before. So that's the prematurity point. Now, the importance of this is that, again, the irony is that in this very same room, this played itself out, as we know from the history that has been set out in this matter. Former President Zuma, when he felt that there was a special plea to be raised, did two things correctly. One, he raised that special plea here in the criminal court in front of Justice Kuhn, wearing a red robe. Two, not only did he raise it here in front of Justice Kuhn, he raised it at the appropriate stage when the plea stage of the trial had happened. Now, by anybody's imagination, we have not reached, well, firstly, we're in the wrong place, but we also have not reached that stage. So a reason has to be given why it is that that law applies to former President Zuma, that when he was aggrieved, he raises the matter in the criminal trial, and he doesn't say, wait, I'm going next door, I'll come back later, Justice Kuhn. But he raises it in front of him and waits for the appropriate stage. He didn't say when they were doing preliminaries, no, I've got an important thing. He had to wait until they say, how do you plead, Mr. Zuma? Then he says, I'm raising the 106.1H plea. Now, what is worse, and this is really where it becomes concerning, is that we are busy developing special laws for former President Zuma. Something colloquially out there is called Zuma law. Because if it's good for him to go to the criminal court to wait for the stage, the appropriate stage, then it should be equally good for Mr. Downer and Ms. Mon. What is worse is that Justice Kuhn, and again I won't take you to the judgment because I assume you know it or you've read it. But we all know that Justice Kuhn said that not only should that 1061H matter not be raised at the beginning, it must actually be raised at the end of the trial. That's the gist of what Justice Kuhn found. He says, no, you must raise it at the end of the trial once the evidence has been raised. Even assuming he's wrong, we're not even at the stage of the pleading. The irony of this, my lord and my ladies, is that I was standing there where my learned friend, Mr. Budlander, number 1, who is standing. And he, not him, but Mr. Trengov, was standing where I'm standing. And I was making the exact same submission that Mr. Budlander is making. Namely that the purpose of a special plea is, after all, to make sure that we don't spend money on some long trial which might take years, if indeed it was fatally flawed. But this court said we were wrong. This court said not only were we wrong, actually that matter should be raised at the end of the trial. So it can be wrong then and right now that one comes here prematurely. That's not justice. That's just playing with the law. And there's a big difference between a court of law and a court of justice. If it is justice that we seek, then we have to ensure that justice is blind. It doesn't matter whether today former President Zuma is the accused or the prosecutor. The same rules must apply. That's why we are here. But no, he was told, no, you must raise it at the end of the trial. And that decision, mind you, was affirmed, as Mr. Budlander said, by the SCA twice and even by the Constitutional Court, in the sense that leave to appeal was not upheld. So I was counting that. That means 15, a minimum of 15 judges hold that view, that there's nothing wrong with a 1061H issue being raised at the end of the trial. Forget even about the beginning or the pleading stage. So that rule must be applied here. Unfortunately, this court has no choice in that. Secondly, this court also has no choice. It is bound by the utterances of Wallace J.A. that I referred to in the Moyo case, because that's the Supreme Court of Appeal of 5 judges. And if it's good enough for Wallace J.A. to say a matter that is that should be determined in the constitutionally preordained forum, then it should be good enough for this court as well. But this court is even bound by the Constitutional Court judgment in Tint, which we have referred to in, I think these are the Downer papers at page 361. And ironically, this was also cited or quoted with approval by Kuhn J. in this court, saying this court should discourage preliminary litigation that appears to have no purpose other than to circumvent the operation of Section 35. Generally, disallowing such litigation would ensure that the trial, and I added my own brackets, the criminal trial, to ensure that the trial court decides the pertinent issues which it is best placed to do, and would ensure that trial starts sooner rather than later. Of course, there can be no absolute rule in this regard, but in the ordinary course of events, and where the purpose of the litigation appears merely to be the avoidance of the application of Section 35(5) or the delay of criminal proceedings, all courts should not entertain it. So, I said page 362 of the It's the MON, sorry. I'm sorry, it's the MON papers, yeah. That's what I was saying. It's our answering affidavit. We quoted this case even in the answering affidavit because of its importance. I'm sorry, but I can give the correct reference, my lady. It's Tint Pty Ltd versus National Director of Public Prosecutions and others. Zuma versus National Director of Public Prosecutors and others. It's 2009-1 SA, page 1, decision of the Constitutional Court, my lady. Thanks. Thank you. And I think the passage I was reading from appears at paragraph 64. Let me just make sure. Yes, it's paragraph 64 of that case. And it's quoted, as I say, with approval in the judgment of this court in the State versus Zuma before Judge Kuhn. And as I say, the Constitutional Court did not mince its words here, and it was not diplomatic. It says the court should not entertain such a thing. Now, we are told in this court, and even in the wrongly decided matter of President of the Republic of South Africa versus Jacob Hlekisa Zuma, which was in January 2023, the one that was relied on. What was actually said there is startling, to say the least. And that's why that, firstly, that case should not even be referred to here, because it was a matter dealing with interim interdict, which has its own special rules. As we all know, an interim interdict, you can even interdict something that's happening in an arbitration. It doesn't presuppose that the second court, so to speak, has jurisdiction. It simply says that the court has jurisdiction to stop whatever the calamity that is feared. So that case is actually completely irrelevant to what we're busy with today. But to the extent that it can be relied on, we associate ourselves with the, again, basic rules of stare decisis, which mean that case is not binding to this court because it's from a different province. At best, it's persuasive. And it would even be more persuasive if there was a single judge here. But now there are 3 judges versus 3 judges in another province. So this court is not bound by that. It wouldn't be bound by it anyway. It would be persuasive. But what is worse is that even if we were in Gauteng, that court would not be binding because it's clearly wrong insofar as it wishes to pit the SCA, for example, with some 1950 case in the Transvaal before a single judge, and which is the case of Solomon. But if you have to go to that case, you go to paragraph 5, and I won't read. That's where they quote 157 of Moyo, which I've already quoted. And then it says at paragraph 6, on the other hand, there is clear authority to the contrary, that a party who is charged by a private prosecutor may indeed approach a civil court for relief as is sought, and then it relies on Solomon versus Magistrate of Pretoria, 1950, bracket 3, in the Transvaal. Pre-constitution, single judge in the previous era. And then the courts do say that that case was applied in Van der Venter, which is another provincial matter, and in some place called the Southeastern Cape, I think, local district, in the case of Netco versus Telichana, and then here in Nandandal. But Nandandal is a different kettle of fish. Nandandal is a review application, which is actually brought, I think, in terms of Paja. So there is no constitutional court equivalent, let alone SCA equivalent, that can countervail Solomon's case, Moyo's case and Tint's case, which are binding to this court, unlike being merely persuasive. So the gist really of this is that what's good for these accused persons, or any accused person, by the way, in the whole country, anyone, even someone who's appearing for stock theft somewhere this morning, if they have a problem with the matter, they must raise it in that criminal court, and at the right time. So the next submissions, therefore, in limine, assuming the court somehow finds a way around Moyo, Wallace J.A.'s utterances and Langa, CJ's utterances in Tint, then would be the issues of the other issues that we raise, namely the state attorney's right to act in the case of Mr. Downer. Now, we are told here that the only answer that you are given is to say no. If you are raising that thing in terms of Rule 7, then you should have done it at a particular stage. And you should, therefore the court must not entertain it. In other words, even if it's a good point, the court must simply not entertain it because it is raised late. Well, I have two answers for that. The first one is that even if you wanted to play those technicalities, one cannot escape from the fact that the real issue that is being raised is the applicability of the State Attorneys Act, which is the only legal basis, at least that we know, in respect of which a private prosecutor can prosecute. There's a case of in the SCA, which happened recently. I think my learned friend, Mr. Stephen Badlander, was in it. We were together in it at some stage in it. And that was the case where the issue to be determined, I'll give the citation now. The issue to be determined was whether the state attorney should pay for Mr. Zuma's defense in criminal proceedings. Now again, it looks like when the shoe is on the other foot, the rules suddenly change. Because two things emanated from that case. One was that the fact that that point was raised late in the SCA, I think for the first time, did not deter many years after the proceedings had started, and there was an awareness issue and so on. But the second one was that unless there is authorization for the state attorney to act in criminal proceedings, which obviously prima facie attached to the person personally, then the state attorney, then Mr. Zuma, it was said in that case, should pay for his own defense. So what does that mean? It means once we've raised this point, all that the other side should have done really is to say, no, there was authorization in terms of the State Attorneys Act, and here it is, and Mr. Zuma, we don't know what you're talking about, because the state attorney is entitled, or the power of attorney if it was a private attorney. It's very simple. You say, no, but here, how can you say Mr. Ntanga here should not act for Mr. Zuma, because he has the power of attorney. But we know that in terms of Rule 7.5, the state attorney is exempted from having to produce a power of attorney. So that point, I will not take it further than that. If the if we understand the defense to be saying, don't raise it now, you must raise it in separate proceedings, which are specific to attack the mandate of the state attorney. Well, maybe that's what will happen. But we thought it would be better to since we're here to raise that issue. But if that is the dilatory plea that is being presented to us, because the point is not going to disappear. The taxpayers' money is being used to defend the private misdemeanors of Mr. Downer. Then the other point which we raise is the non-joinder of Ms. Mon. Now, this might look like a trivial point, but it is not. Remember that firstly, this court refused to consolidate. We actually wanted a consolidation of these matters, which would have gotten rid of that point. And the court refused to consolidate for whatever good reason. So these matters, although for the sake of convenience are being heard together here, they are separate matters. So it is open to say that Ms. Mon should have joined Mr. Downer. She says in her own affidavit, my co-accused is Mr. Downer. So I've never heard of a situation where an accused person, in fact, even in the Section 106 matter that we raised here, the representatives of Thales, unfortunately for them, had to be here day in, day out as we were dealing with that matter. Why? Because they had nothing to do with the 106. They were only a party to this simply because, and they had to fly from Joburg every time we argue the matter, simply because they are accused number 2. They have an obvious interest in the matter. But now we hear something novel, new law. We are told that Ms. Mon has waived her right to be joined. I've never heard of such a thing. If she is has to be joined by law, not a joinder of necessity, not a joinder of convenience, as that expression is used, then she must be here. So I can't say, for example, I'm suing this department because they didn't give a particular tender, but one of the winning bidder says it's fine, you can do it without me, and therefore that means that I should not have joined them. They are mixing up two different things. If the person says, I wish to abide, that's fine. You can't force them to come to court. But as to whether you should have joined them when you were starting your proceedings, there can be no debate. Even a first-year student would know that that's a joinder which you must make. And that's the issue we're raising. So Mr. Downer or Mr. Mon, Mr. Downer did not know prophetically in October that one day in 2023 Ms. Mon is going to waive her right, unless there's other issues that we don't know. And so that subsequent waiver cannot be a cure to the actual failure to join. Let alone the fact that to the extent that they seek to rely on Nandalal, the decision of this court, then it makes the non-joinder point even more serious. Because remember, if you are doing that, you are then actually setting aside the decision, in the case of Ms. Mon, of the official who issued the nolle prosequi, and then in the case of both of them, of the registrar or official who issued the summons. But none of those people have been joined. How do you begin to review or set aside the decision of the clerk of the court or whoever it is who issued the nolle prosequi, or even the National Director of Public Prosecutions who issued the nolle prosequi, and or the magistrates, clerk of the court or the registrar of this court who issued the summons in their absence, without them even knowing? They'll hear one day that, oh, that administrative act you performed in September last year has been set aside. They're going to say, what? What are you talking about? Nobody cites them. And for that proposition, you don't even have to go far. You must just go to the front page of the case, the Gauteng case of President of the Republic of South Africa versus Zuma. We there, because we were contest, or rather, we were the prosecutor. Let's say we were the NP, the private NPA. We're joined with a second respondent, the Director of Public Prosecution of KwaZulu-Natal. That's because she had issued the nolle prosecute. The NPA, for obvious reasons, and the Registrar of the High Court, because they had issued the summons. And that's why those people were essential, unless if we're going to be told that they've also waived, quote unquote, they've waived their right to have their decisions set aside in their absence. A strange phenomenon. But that's fine. Let's assume all of those can be overcome somehow, which I don't know how. Then we come to the merits of the challenge. Now here, I have to differentiate it like this. Sorry. Yes. As I said at the beginning, I'll deal with the common issues that are raised by both of them, and I'll try to do it in such a way that I start with the non-points really that should take 5 minutes to deal with. And I said let's pack. If you go to page 366. Okay, let me just make sure that yes. So it's 366 of the MON file. Just for the sake of convenience, so that the court doesn't have to. That's the place which I will use when I refer to the section. Remember, I said that the starting point on the merits should be the section that brought us here, and it's a very simple law, really. Honestly, it's very, very simple. Forget about the purpose thereof now, and the 15 years and what have you. But it's an elementary piece of legislation. Doesn't need any magical interpretation. It says very, very simply, no person shall, without the permission of the National Director or a person authorized in writing by the NDPP, disclose to any other person. Please underline that. There's no qualification. No person shall disclose to any other person. So unless if you are not a person, then you are not hit by this. The legislature doesn't do things for fun. When it gives such a wide definition, it is deliberate. If it wanted to say no person except a journalist, or no person except this and the other, it would have said so. And the exceptions are at the bottom of the thing. But it says no person shall, without the permission, disclose to any other person. Here's another thing. Any information. And this is where the problem is. Because we are told here about confidentiality and this and that and the publication in News 24 and what have you. But this law is very simple. It doesn't say you may not disclose any confidential information. It says any information. And then it says at B, you may also not disclose the contents of any document or any other item in the possession of the prosecuting authority. What is so difficult about that? Any record of rather contents of any document, I'm jumping the book, or any other item in the possession of the prosecuting authority. Any document. Whether it's private or confidential or whatever, doesn't matter. And here's the catch, the point that we make in our heads. The obfuscation that you get in this case, and if you can overcome this, the case will become much easier, is that deliberately there is a conflation of terms, 3 in particular, and I'll say that in relation to the Karen Mon application. It's deliberate. I have no doubt about it. I've looked at the papers carefully. They deliberately conflate publication, confidentiality, and disclosure. Publication, confidentiality, and disclosure. And those 3 things must be dealt with separately. The statute only prohibits disclosure. It doesn't say anything. Whether I give it to Mr. Masuku, I disclose it to Mr. Masuku, and he takes it and puts it in his wardrobe, that information, and never does anything with it, I must go to jail for 15 years if I'm the prosecutor. The fact that what I give to my learned friend, Mr. Masuku, happens to be confidential medical information is just aggravation. It makes it worse. It might feature when we're talking about sentence at the end. It might feature that not only did I give him information, but I actually gave him, or rather, I gave him somebody else's private medical information. But it has absolutely nothing to do with the statute. Similarly, the fact that I give this document, I can give it to 3 people. One is an engineer, the other one is a doctor, the other one is a journalist. I'm still foul of this section. The fact that the one who's a journalist then goes on to publish it in whatever publication doesn't make them guiltier than the engineer and the doctor who do not publish it or do not publicize it. The crime is completed in all 3 of those accused persons. And what they do with it might differ. This one might tell 100 people, the other one tell 1,000 people. Maybe the one who tells 1,000 people must spend more time in jail or whatever. But that's a question of sentence. It's not a question of conviction, of the conviction or the... So this red herring about journalists, this and whatever, has got nothing to do. If Ms. Mon, to make it this clearer, if it's not as clear, if she had been, the information had been leaked to her, but in her good judgment, she forgot, well, in her good judgment, she didn't publish it, but let's make it even worse. She just put it in her, somewhere next to her computer and forgot about it, and never wrote a story. The crime would still be complete, because it's the disclosure of the information. And that goes to the unavoidable issue of the purpose of the statute. That statute was enacted to ensure that our prosecuting authorities are independent, fair, pure, non-partisan, and do their job professionally. That's all. That's all that differentiates me from Mr. Downer and Mr. Breitenbach and all these people. if I disclose information that I got from former President Zuma to my friends, nothing will happen to me. I'll just be reckless. But if I'm a prosecutor, I must go to jail for 15 years. The same me. It's still me. But simply because now I'm acting for a private citizen, I can go and talk about it in the shebeen. But if I'm a prosecutor, I may not breathe a word about it. The worst thing that can happen is that President Zuma, when he hears that I was talking about his matters in the shebeen, he might just decide to get another advocate who doesn't talk too much in the shebeen. That's all. That's the worst thing that will happen. But he can't take me to jail. But if I'm a prosecutor, I must go to jail. That, with the greatest respect, my ladies and my lord, is what we are here about. Nothing else. Forget about all these flowery things. Did Mr. Downer or Mr. Breitenbach or whoever it is in the NPA who was engaged, let's go to the statute, without the permission of the national director or a person authorized in writing by the national director, disclose to any other person, Ms. Mon, any information which came to his or her knowledge in the performance of his or her functions in terms of this act, or the contents of any document or any other item in the possession of the prosecuting authority. Yes or no? If he didn't, we'll apologize. If he did, he must be prosecuted and imprisoned. Finish and clear. Was it what Mr. Downer or Mr. Breitenbach disclosed to Ms. Mon, did it amount to information and or a document? The answer is yes on both. In fact, they are guilty of both 416A and 416B. Yes. It does. I'll come to that. Yes, my lady. It does. It does. That is the so-called sanctioning point. I'll come to it. That's one of the 4 points that. Let me put it this way. Maybe let me address it now, my lady, so that I don't forget to come back to it. Firstly, the answer is that from the point of view of the public, the citizenry, it makes no difference because it's either one, there's one accused or two accused, let's say. But that somebody, nameless, don't even call them a name, give them a name yet. That somebody acting for the NPA disclosed information to any other person means that the crime has been completed. Then we must then say, who is that somebody? Now, my learned friend, Mr. Badlander Sr., says that, Mr. Breitenbach is here. He says, I did it. Well, apart from putting Mr. Breitenbach under the bus, that statement does not assist Mr. Downer for the following reason. I don't know if I even have to make this submission. I can't go and rob a bank with somebody else or with 4 other people. And then when they catch me, I say, no, I was not the only one. They say, oh, why didn't you tell us, Mr. Pof? Please go home.
But you did not say, I was not there when the robbery happened.
And I'm coming to that. I'm coming to that. Please be patient, my lady. Let's first accept the first proposition, that I cannot do that. I can't say I was not the only one who robbed the bank. Full stop. Put that aside. Neither can I say, again, it's Criminal Law 101. Every book in criminal law has a chapter called Participation in Crime. And that chapter deals with the following 3 or 4 things, among other things. It deals with what we know as common purpose, which is the point you are alluding to, my lady. In other words, you may not have been the only one, but were you part of did you participate in the crime? That's the first issue. Let's put that aside as well. It also deals with something called accomplices. That chapter in every criminal law book. And that again means you can be an accomplice even if you are not the one who pulled the trigger, right? Or who took the money from the vault. And lastly, it deals with something called accessories after the fact, which means you may not have been there. That's your point. You may not have been there when the bank robbery was done, but if I come to you even 6 months later and I say, hey, you know what, wink wink, I'm the one who robbed that bank, can you hide this money? And you do that, then you are an accessory after the fact. So the presence or absence is completely irrelevant for accessories. But just to allay again Mr. Budlander Sr.'s fears, because he addressed this court about accessory after the fact. I'm not sure which one. I think it was Mr. Budlander Sr. We do not say that Mr. Downer was an accessory after the fact, because we don't have to. He may or may not be. But an accessory after the fact that is covered in terms of Section 257 of the Criminal Procedure Act. An accessory after the fact is not something you necessarily have to plead in the substantial statement of fact, because it's something called a competent verdict. Another chapter, this time in a class of criminal procedure. So Section 257 and 258 actually falls under the chapter called competent verdicts, the big chapter, the big heading. So can't get my CPA. Oops. But anyway, the court knows this. Even if he was an accessory after the fact, he would have been covered by that section. What we have said in no uncertain terms is that Mr. Downer is an accomplice. We say he's either a perpetrator, again that goes back to that chapter of ours, a perpetrator, co-perpetrator, or an accomplice. It doesn't matter for the current purposes which he is. Why? Because, and that goes to the heart of your question, Justice Masipa, because we allege, right? Allege. Are we going to prove it in the criminal court? I don't know. But we allege that he performed an act of association, an act of sanctioning. In fact, I'm wrong, sorry. He, Mr. Downer, alleges, not us. He says Mr. Breitenbach gave the document on the 9th at 16 something or whatever. Then he says later that day, Mr. Breitenbach told me, Mr. Downer, that he has done so. And I then said, oh, well, no, we can come back to her tomorrow. Oh, yes, I'll let you know when it's filed and what have you. That's Mr. Downer. That's a confession in simple English. He says, when he had a duty, and we all know, at least as lawyers, that a crime like that, which is committed by omission, arises when there's a duty to act. So what was the duty of Mr. Downer when he was told by Mr. Breitenbach that he has just broken the law? His duty was to say, what? Did you really do that? And go to the authorities. Those authorities are to be found in the NPA or in the police or wherever he had to go. And Justice I'll refer to, I'm sorry, there's I think it's the Downer file, page 123. So it's not me who's inventing this. It's the law. Mr. Downer attaches to his papers the policy, what he calls, it's BD10. BD standing for Billy Downer. Annexure BD10. He has put a explanatory note to the directives around the performance of work by prosecutors. And he says that document says the following, among other things. Prosecutors should refrain from making inappropriate media statements, public communications, or comments. And it says the deputy directors and senior public prosecutors may act as spokespersons for the NPA on matters pertaining to the prosecution policy or any criminal prosecution. And then if any other member of the NPA is required to make a statement and so on to the media, comment in public or deliver a public address, the authorization of the DPP must be obtained. And here's the key. It says the purpose of responding to media or public inquiries, assuming all these authorizations have now been obtained, is to assist the public in understanding the nature and course of criminal proceedings, and not to prejudice the parties before the court who cannot defend themselves against public comment. That means not to prejudice persons like former President Zuma. That's their own policy. He broke it. But again, if you don't believe me, our NPA Act expressly encapsulates, I think is the word, or receives the United Nations guidelines on prosecutions. It's part of our policy. It's actually even referred in the policy. And this is what it says. And again, Mr. Downer has kindly put it at BD 11, paragraph at page 125 of the Downer file. And this is what must have informed Section 41.6. The United Nations concerned about the same things that concern former President Zuma and should concern every citizen of this country about prosecutorial conduct, says at paragraph 12, the role of prosecutors in criminal proceedings. Paragraph 12, prosecutors shall, in accordance with the law, perform their duties fairly, consistently, and expeditiously, and respect and protect human dignity and uphold human rights. Let's just pause there. They must respect human dignity. And if the way to respect human dignity is to give away people's private medical information, which they may, for good or bad reasons, have kept away from their family or their friends or whatever. We all know that. I'm sure all of us have a relative somewhere who was told, you have 2 weeks to live or whatever. And they decide, no, I'm not going to put my family through that. I'll keep that to myself or whatever. And if I went and then said, no, I'm just going to go around and telling everyone who cares that so-and-so has 2 weeks to live, and you say I did not affect their dignity, then we live in another world. And it says they must also uphold human rights, thus contributing to ensuring that due process and the smooth functioning of the criminal justice system. And then at 13 it says, in performance of their duties, prosecutors shall carry out their functions impartially and avoid all political, social, religious, racist, especially here, cultural, and sexual or any other kind of discrimination. In other words, all accused persons must be treated the same. There should be no special laws for Zuma and others for the favored people. And then it says, they must keep matters, this is the heart now of the matter, at paragraph C, 13C. Keep matters in their possession confidential. That is what informed our section 41.6. Unless the performance of the duty or needs of justice require otherwise. So again, it's that situation where unless immediately throws the onus on them. They must tell us why it was different here. Consider the views and concerns of victims when their personal interests are affected. Okay. Then go to the bottom of that page. Observance of the guidelines. 23. Prosecutors shall respect and present guidelines, and respect the present guidelines. They shall also, to the best of their capability, prevent or actively oppose any violation thereof, unlike our Mr. Downer. And number 24, prosecutors who have reason to believe that a violation of the present guidelines, that's your point, Justice Masipa, about whether you are present or you are just told by someone else after they have broken the law. It says, prosecutors who have reason to believe that a violation of the present guidelines has occurred or is about to occur shall report the matter to the superior authorities and, when necessary, to other appropriate authorities or organs of state. There are missing words there. You can just write them down. It's just 3 words. In that, it should say authorities and organs vested with reviewing or remedial power. So the duty is inescapable, and that duty was breached, violated, ignored, and actually it's disgraceful that one person authorized by the NPA can go to another and say, I've just given away information, and the other one says, oh, well, how do we assist? Instead of saying, what are you saying? I'm going to report you to the authorities in line with my duties that arise from the UN guidelines. That is what we have here. It is nothing. Sorry, I'm sorry. Sorry, madam. Yeah.
How do you decide then who the accused person is? Because it appears from the facts that the main perpetrator would then be Mr. President.
Yes.
Then we don't see him appearing anywhere on
No.
the summary, the notice of prosecution that motivates to be. How do we decide we're just going to be?
Now, my lady, that is just incorrect factually. We do see Mr. Breitenbach appearing. If you go to page 55 of the Downer file, in fact, before you do that, you can just put a finger there. And by the way, in the statement of fact, we refer to the UN guidelines at paragraph 6 at page 45, just in passing. But apropos what you are raising, Mr. Breitenbach, his first name is Andrew. And so if you go to paragraph 48, you see it says Andrew Breitenbach, a duly admitted advocate, was one of the, at all material times, one of the private advocates. I'm sorry, ma'am. 48 of the Downer file. No, page 48, paragraph 13. That's the so-called summary of facts. Your ladyship said we don't see him appearing in the summary of facts. It's called the summary of substantial facts in terms of section 144.3a of the Act 51 of 1977. I don't know if the pages are, did you find it, my lady? Yes. Oh, thank you. Right. So Mr. Breitenbach is referred to at paragraph 13. And then he is also referred to, sorry.
Well, is he referred to as a perpetrator of offense? Just like mention is made of Mr. Luka, there,
yes,
and a whole lot of other people.
Yes.
Is he referred to the person, or is he referred to he is the perpetrator?
Yes.
That's my point.
No, my lady, let's walk slowly. So the first thing is that he's referred to. We agree there. Okay, good. Now, the next question is he referred to, in what capacity is he referred to? Okay. He's referred to in two separate capacities. One, as a perpetrator, co-perpetrator, or accomplice. And that's one. When I say two, I mean, it appears in the very same document. Let's go to paragraph sorry, where were we? We're in 14. Sorry, I've got the summary of facts. No, let's go to the. Let's go back to the complaint, the police complaint, which really is where this whole thing started. That was on the 21st of October. Some of facts. Now I'm coming there. I want to asking about the summary of facts. My lady, let me just say this. I'll find you the references because I'm chasing time. The answer to that question is yes and yes and yes. We say in our affidavit that in the police complaint, remember, there's a reason why Section 7 says when a DPP issues a nolle prosequi, he or she must certify that they've read the police statement and the complaint. Because otherwise, how do you do that? And no, that's not the police statement. The 21st of October. The reason is simply this, my lady. When you issue that nolle prosequi, you are doing so in relation to those who are mentioned and sometimes those who are not even mentioned. Anyway, we'll find it. It's the complaint statement. So he's referred there many times. He's also referred in this document I was reading to you now, the indictment, as a witness. Yeah. Of Mon, yes. It appears in many places, but thank you, my lord. That's one of them. 333. Yeah, that's more rememberable. That's 33 of the Mon, or 91 of 91 of Downer. But let's rather go to the one that His Lordship has kindly found. Okay, you'll see at page 338, on or about 9 and 10 August, Advocate W.J. Downer authorized or sanctioned the disclosure by Advocate A. Breitenbach, SC, that's the same person, of a confidential medical person to one newspaper journalist, Ms. Karen Mon. That's the first time he's mentioned. Then to assist your ladyship about whether he's an accomplice or whatever, we say at paragraph 14, as can be observed from the annexures, the most prominent feature of this case is that the complaints are based on conduct which has already been admitted by the suspects, in plural, okay, under oath. 14, madam. That's a 339, sorry. Yeah. Okay, so the reason why we use the word suspects there in plural is because there are many people. And then it says at 16, this criminal complaint is completely separate cause of action which must be pursued to bring the suspects to book and to cause them to account for their own criminal conduct, irrespective of the outcome of the Section 106, which you will remember was still pending.
So you say the issue of this affidavit, the Director of Prosecution would have identified Mr. Breitenbach as one of the suspects?
No. No. Your first question was, is Mr. Breitenbach mentioned? We've gone past that. Yes. The second question was, in how is he mentioned? Is he just mentioned, you know, just for fun in passing, or as a criminal? Yes. So I'm saying yes, and for that you must also look at paragraph 18, which says that the purpose of bringing the information contained in this affidavit to the attention of the police is to initiate a process which must necessarily lead to the prosecution of the suspects, failing which a certificate to the contrary must be duly issued by the NDPP, who is incidentally the person ultimately responsible for the deployment of the suspects. And then it says the criminal violations set out attached documents should serve as a useful basis for determining the scope of criminal investigations that the SAPS may conduct in this complaint and the inclusion of further suspects and or accomplices. So there is no one reading this who would not understand that here the complaint first and foremost foreshadowed many suspects, and that the people who are named there, who include Mr. Breitenbach, by the way, are those people. But let me make your life easier, my lady. Like all prosecutors, public or private, it can never be an answer that if you want to prosecute, if there are two people who have committed a crime, myself and my learned friend, Mr. Buthelezi, and I, as the prosecutor, decides that Mr. Buthelezi will be a witness and I'll be an accused, then you say, where's Mr. Buthelezi? Why did you only prosecute Mr. Mpofu? The fact that Mr. Breitenbach, apart from everything I've said now, that he appears and is identified as a suspect, just like Ms. Mon is included or listed as a witness, and Ms. Mon is listed as an accused, or Mr. Downer, quite frankly, is neither here nor there. So so that's the first point. The second point, and that goes now, I know this takes me where I was going to go later, but since we're here, let's kill that point. It goes to the complaint by Ms. Mon that the Nole prosecutor doesn't refer to her. The same answer that I've just given you, my lady, pertains to that, because let's remember the facts. What are the facts? We must always be guided by the facts. The facts are as follows. Having said all these things and postulated various suspects and accomplices and what have you, we then said, as I read out the paragraph 18, please go and investigate and include, if you find other suspects that we don't even know about, we're not the police. The police might have found that there's also a Mr. Smith or whatever who's involved in this. That's their job, not ours. We are just the prosecutor. All we're saying is that go and investigate and find whoever you find and charge them. Right? But at the very least, the ones that we have mentioned here, Ms. Mon, Mr. Breitenbach, Mr. Ramaphosa, Mr. Lamola, I think Ms. Batoi were the people who were mentioned by name. So we're saying those people are mentioned by name. There's no debate about that. But there might be Mr. Smith and Ms. XYZ. Yeah. So here's the issue. The NDPP, fortunately, my lady, understood exactly that is what they were asked to do. Because you look at their decision, they say, she says, I've decided not to prosecute any person in relation to this crime.
So you refer to
No, I'm not. Long before that. That was just when they were trying to play gymnastics, you know, to save the day. My lady, if you go to, I think it's the Downer file, the records, 500 and, okay, now it's volume 6 of the MON file, I'm sorry. Go to page 574, 575. You'll realize that a whole year before they came up with this trickery that no, we did not want to include Ms. Mon or Mr. Ramaphosa or what have you. Long before that, this is what they said. On the 5th of April 2022, last year, Advocate Ramuthar, who's the Deputy Director of Public Prosecutions in Durban, said, I decline to prosecute any person in connection with this matter. Any person. Right? Of course, later they tried to escape the words of their own. And that, by the way, what then happened, my lady, is, and I'll paraphrase this, is what is set out. This Nole prosecutor of the 6th of June only mentions Mr. Downer. So we're going to raise this point before this court. My learned attorney, Mr. Ntanga, then writes a letter to the NDPP on the 30th of September 2022. You'll find that at 528. It's called JSA1. Mr. Ntanga says, please, we have, it's a paragraph 7 in the next 529, says, the purpose of this letter is to seek clarity from yourself, that's the NDPP and others, as to whether or not the decision dealing to prosecute, indeed, it should be like refusing to prosecute or something like that. Yeah. Indeed, also included Ms. Mon, as we contend it does, upon a contextual and holistic and business-like interpretation of the certificate. Our view is fortified by the belief that in issuing the certificate, the NDPP had read the statements, the one that I just read to this court. And we therefore request you to kindly issue an amended or additional certificate which makes it clear that it refers to Ms. Mon. Alternatively, accept this letter as an invitation to make a decision one way or the other on the prosecution of Ms. Mon by the NPA. If you decline to prosecute, please urgently furnish us with the relevant certificate to that effect. Right? That's the 30th of June. On the 3rd of November, or rather on the 25th October, you'll find that at 5:40. The NDPP, because of their bias inherent in this matter, and which is probably understandable because these are their own employees and so on, come and give us the what you call the party line. So they say Ms. Mon was not contemplated as a suspect, but rather only as a witness. You'll get that at 5:40. That was I'm now required to decide. If I'm now required to decide whether or not to prosecute her, I require a full investigation to be conducted before I make such a decision. Now, you know, this is when my learned attorney, Mr. Ntanga, then stopped being Mr. Nice Guy. On the 3rd of November, he writes the following letter. He says, be that as it may, he says, you didn't apologize, we gave you a deadline, you didn't meet it. Be that as it may, the purpose of this letter is to inform you that our client roundly rejects your decision to exclude Ms. Mon from the ambit of the nolle prosequi certificate as unreasonable, irrational, biased, and motivated by ulterior and improper motives. Your inherently biased attitude in this matter is understandably based on the fact that the prosecution involves Advocate Downer SC, who is your colleague and whom the NPA has repeatedly praised in public, in spite of and in opposition to our client's exercise of his constitutionally protected rights to institute a private prosecution. This attitude previously was exemplified by your transparent delaying tactics in producing the nolle prosequi certificate on 6 June, despite having made your decision not to prosecute on 7th April. Furthermore, the NPA has a direct interest in the prosecution in that it is funding the defense of accused number 1. That's the whole issue about the state attorney. Your automatic bias must also be viewed against the issue of financial interest in addition to the relationship-based interest. It is illogical to claim that Ms. Mon was, quote, contemplated as a witness when the affidavit, which you are deemed to have read, clearly identifies her as an accomplice and a suspect. That is what was clearly expressed by the complainant, to use your phrase. And then we go on about, we quote the paragraphs that I quoted to you earlier, my lady, at 5.1. Paragraph 11 of the complaint statement, paragraph 7, paragraph 15, paragraph 18, paragraph 19, and at 5.6 and then we quote the certificate itself. It says, I, Elaine Zungu, that's the DPP, duly appointed as DPP, certify that I have seen all the statements and affidavits on which the charge particularized below is based, and I decline to prosecute at the instance of the state. Then we quote Ndumeni, which I won't go into. That's the one about context and purpose. And then we say, in any event, you have sufficient time to make a decision. We say, this is paragraph 7. Given all these objective facts and in the blatantly irrationality of your decision, it is incumbent upon you to assist in avoiding unnecessary and protracted litigation in this matter by forthwith 1, reversing the aforesaid decision, 2, making a decision whether or not to prosecute Ms. Mon, 3, issuing the requisite amended or separate nolle prosequi certificate by the deadline set out below. And then we are instructed to demand, as we hereby do, that you furnish us with your urgent response by no later than Friday, 11th November, failing which urgent application to compel and to review your decision will be launched without any further notice, and which punitive cost a bonus will be sought personally against you and or the NDPP on the grounds of conduct which is patently unreasonable in bad faith and tainted by bias. So Mr. Zuma then says, well, if you're not going to give me this, I'm going to go to court. That, my lady, is what brought, then they capitulated, to just put it bluntly. At page 548, after this letter, then on the 21st of November, that's how we got if we hadn't threatened the legal action, we would have been left with that nonsense of saying that she was not contemplated as a. So even here, I think they found it very difficult, shame. So this is what they said. The certificate is now issued 21st November, a few days later. I, Elaine Zungu, duly appointed Director of Public Prosecution, KwaZulu-Natal, hereby certify that I have seen all the statements and affidavits on which, I'm at 548, on which the charge particularized below is based, and that I decline to prosecute any person in connection with this matter at the instance of the state, which is exactly what we have been saying to them, that the even though the 6 June certificate is written Billy Downer, if you interpret it in the context of the police statement and what have you, and the suspects that are named there, then obviously it embraces them. So eventually they saw the light, or apparently they took legal advice somewhere, and then they issued this certificate. So that was the end of that little trick. And so that's what we call clarificatory certificate, and it must not be elevated to anything more than that. And there's another deception, to try and portray the second certificate as if it's a standalone certificate. No. We demanded of it as a clarificatory certificate, but our insistence has always been that the 6 June certificate, properly interpreted, embraces Ms. Mon, Mr. Breitenbach, whoever, Mr. Ramaphosa, Mr. Lamola, Ms. Patoi, whoever is mentioned in that statement. So that's how. So to come here now, after all this, now in 2023, in March, and still assert, my learned friends, Mr. Badlander, Stephen Badlander, to come here and say the nolle prosequi does not include Ms. Mon. It's just really, really, really just, after what I've just described to you, how the NPA itself, after being compelled to do so, clarified and widened the certificate to include any person. And if that is not enough, by the way, the NPA, in another act of irregularity, and that will be referred to in the Ramaphosa case. This time they were trying to save someone else. So they said, no, if it wasn't so tragic, it would have been laughable. On the 24th or 21st of December, just before Christmas, they issued a statement and said, no, this is now head office. We want to tell you, world, that Mr. Ramaphosa is not included in the nolle prosequi, because that nolle prosequi only applies to the persons who are mentioned in the police complaint. So obviously this was someone in head office who had not read the police complaint. So we told them, yes, but Mr. Ramaphosa is mentioned in the police complaint. And that was the end of that. We've never heard from them since then. And but there's also, it's called, for the purposes of this particular matter, it's common cause that Ms. Mon is mentioned in the statement as well. So even on that version, which was for ulterior purposes, where they say it's only the people who are mentioned, both Ms. Mon and at least Ms. Mon is in. So I don't know why we're here debating this simple and obvious fact. But in any event, my lady, I think it was my learned friend, Mr. Badlander, who said he's never heard of this thing about receiving something being a crime. Maybe it was Mr. Stephen Badlander. Well, if they haven't heard of it, that's fine. That's tough luck, because we have some of our crimes involve that. There's the colloquial saying that says, where there's a corrupter, there's a corruptee. There's even a crime of receiving stolen property, knowing it to be stolen. So all we're saying in this context is that the discloser, to steal that Anglicism, the discloser is as guilty as the disclosee. In other words, if I disclose the information obtained from, I've read the statute, I'm not going to read it again, and you receive it, then you are, at best for you, an accomplice. But it doesn't matter, because those things will be argued in the criminal case. For now, the question is whether you are criminally liable. Whether it's as an accomplice or an accessory after the fact or what have you is not for now. So okay. Well, thank you. As God pleases. That's good.
It's not.
Yeah, I just want to switch it off now.
Let's go. And because they like to take their time and then when they feel like and then you know, I don't know what I'm
you know, I'm
Exactly. And even what's
paragraph?
And we page how we can cope with this because they are controlling narrative.
Probably. Which one?
They know critical. Yeah. Finance. Yeah. By pattern. Would have taken very in advance. Absolutely. So you play about manje. By activate Gala.
Coming one second.
My time is fine.
The ICC is the ICC International Criminal Court. And why is she warrant of arrest of Putin? Oh, is also. No, who's over one? Look at that. You know, when I get to know what happened to Xi Jinping.
Where? No, that's fine. I know this one. Yeah, no, that's fine. And Uti, why is it page? Yeah, I wanted to know where it's referred to that. It says PD, University Town. Yeah. No, I don't know. Oh, I need 2009. Zuma. SSG, PSP. one with one on motives. Uviani quoted it in his head. Let me. I'll use Vianney's head.
The one about motive?
Yeah.
We've quoted it in our heads.
Where? No, but
did you cancel it?
No, it's there, but it's not. You remember they say no, 38. But we goes on to 37. Some near 38. Yeah. So I want to show them how to 38. We are not Babulala. Yeah, here it is. It's in Vianney's head.
I was about to say she's the silent assassin.
I mean, this kind of. No, it's not.
No, you're right. But you're right.
Yeah. Where's no, it's fine. Yeah, that's the one number. It's got a zombie. No, man. My head's up here.
Okay, hold on.
Okay, yeah, ungabamba in the meantime.
No, it's just if you happen to have one.
Only if you have one.
I've got a slightly compromised grimy guy there.
I wouldn't take it.
Yeah.
Thank you for that.
No.
It's
It's sort of sand. It's not that somewhere. It must have been put there by one of the children.
Flag.
Thank you for the good advice. You must not.
Well, I'll say you are a person, clearly a person of impeccable judgment.
It's really quite, it's insightful. It takes a lot of years of experience.
All I want to know is if you send me a bill for the brush, can I get it back on medical aid?
Thank you. You'll eat them all, Sean, but thanks for your efforts. That's just weakness you share with your wife. She can file them anywhere. She eat a whole box.
Yes. Thank you, my lord. My lord, I just wanted to as it were, wrap up the point that I was busy with. As I said, the argument just took us there, fortunately, but just so that I don't go back to it, which was the issue, one of the what I call the peculiar points, which are specifically only raised by the applicant, Ms. Mon, and that was the issue of the nolle prosequi. In my respectful submission, the response that I gave to one of the justices about that covers the why that point is not a good point, and why the nolle prosequi clearly, at least once it was clarified at our insistence by the NPA, that it is wider than merely referring to Mr. Dana, which in any event was always the case, then that point, with respect, should have just been abandoned. But it's being pursued nevertheless. And this is despite the fact that the NPA received legal advice. And this is really, this also goes to the question of costs, the kind of cost order that we should be entitled to here, which should be punitive in nature. Because it's one thing, it's understandable, with respect, my ladies and my lord, that Ms. Mon, and now let's not even talk about her lawyers, let's just say as a lay person who's not a lawyer, it's understandable that she could say, oh, here's this nolle prosequi, but where's my name in it? I mean, the lawyers should have explained it to her, obviously, but I'm putting the lawyers aside. But once it has been explained that, no, a nolle prosequi is not read like that. The reason why Section 7 insists that the DPP concerned must specifically say, in fact, whether she specifically says it or not, it is deemed that she has read the complaint, police complaint, the affidavit, and all that. Why did the law say that in Section 7(1)? Because it did not want these kinds of situations where an accused person comes back and says, no, my name is not there. And we say, no, it was in the statement. And then the DPP says, oh, I didn't read the statement. By the mere act of releasing a nolle prosequi, she is representing that she has read the statements and she knows that there are many suspects. So all I'm saying is that once all that was clarified as between the attorneys and the new certificate, the clarificatory certificate was issued, that point should have been abandoned at that point. So from that point onwards, which is the 21st of November, the costs of pursuing that particular point should be visited on Ms. Mon on a punitive scale, and even her attorneys, because they themselves should also have said, okay, well, this point maybe was a good try, but now it has expired. And that goes to something very significant. And it is that it's another point which I think we can get rid of very literally in 5 minutes. Another non-point. You'll remember that both applicants raised the Section 7(1) point of saying that former President Zuma has no peculiar interest or injury suffered as a result of the alleged crime. I mean, really? Can you say that? Remember, for the purposes of this point, you have to assume that everything is true. You have to assume that his medical information, as a person, forget that he's a former president and all that, and that because of that, in any event, his information is protected by secrecy acts and all sorts of things. Forget that. Assume this was just Mr. Themba Mkhize down the road. Can anyone really with a straight face say that the dissemination of the private medical information of that person is nothing? What are they talking about? They are not suffering any injury. When that person says, I specifically withheld some of this information, even from my children, I specifically made sure that nobody knew, at least I didn't, and I'm his lawyer, but I didn't know that he was suffering from a life-threatening disease. I didn't. Maybe other people did. I didn't know that there had been an 18 months wait for a particular procedure. I didn't know that. And that is the information that was leaked. And we were told with a straight face that what is it going on about? He hasn't suffered any injury. Quite apart from the fact that that issue in any event should be, it's a matter of title to prosecute. That's vintage Section 106 issue, if Justice Kuhn is to be believed. Mr. Badlander, the junior, correctly called it a jurisdictional prerequisite as envisaged in Section 7(1). But its absence is a matter of title to prosecute. Because what in simple English, not in simple English, in legalese, what you are saying when you are saying a person doesn't have a peculiar interest, you are simply saying they don't have a title to prosecute in terms of Section 7.1. So that issue should not even be raised there, it should be raised in the criminal court. But for the purposes of this argument, let's assume it can be raised here. It has no merit. It is insulting, actually, for anyone to even utter that. It's the height of arrogance and bigotry to say he must just deal with it, you know, if his information is being bandied about all over or has been released by the prosecutors. So I don't think we need to spend time on that for the two reasons: that A, it should be raised later in the section under Section 106, and B, even if it is to be raised here, it is completely meritless. Even Justice Kuhn could not get himself to saying that this doesn't matter. He said it to the extent that it is injurious. It did not affect the free trial rights, which is something he was dealing with. But at least there was a half acknowledgement that of something that really any human being, one doesn't have to be a lawyer to understand that the dissemination of your medical information is something that's dear to all of us. I wouldn't like, even if I have a headache, I don't want the whole world to know about it necessarily, let alone a life-threatening disease. So that point with respect, we shouldn't waste time on it. So let's get to the issues that they do raise. We've spoken about the Ms. Mons being clearly covered by the nolle prosequi. We've spoken about the Section 7.1. But before I go to the next topic, if I may, if the court allows me, just to round off a point that was raised by Justice Masipa around about this other red herring of, like, was it this one, was it that one, was it both, was it Downer, was it Breitenbach, was it our case is very clear that by his failure to do the things that I've said should be done in terms of the UN guidelines and other instruments. And in that respect, I've taken the liberty, I beg leave to hand up copies of the government gazette this is the same document that Mr. Downer was referring to, and I've said that it's some of it was not complete, but that's the UN document I referred to. But this is where it is made clear that it is part of our law, or it's subsumed. I remember struggling for the correct word here. So this is Government Gazette of 29 December 2010, Department of Justice, and Code of Conduct under Section 22(6) of the NPA Act, signed by the then NDPP, Mr. Menzi, Advocate Menzi Simelane. On the front page, it says, I, Menzi Simelane, National Director Prosecutor, acting under Section 22(6), and so on and so on. But I want to draw the attention of the court to this next page, where it says, in framing this code, the minister, you remember in 22(6)(a), it empowers the minister to do this kind of thing, regulations and other things. In framing this code, the minister, deputy national directors of public prosecution and directors of public prosecutions were consulted as prescribed by the Act. Due account was taken earlier to the values and principles enshrined in the Constitution of the Republic, the aims to be achieved as set out in the Act, the United Nations guidelines on the role of prosecutor, as well as standards of professional responsibility and so on. So South Africa is not just a signatory to that UN document, but it has been specifically received. So so the duty to act. So the failure of Mr. Downer to act is a crime because he had a duty to act under these guidelines, among other things. But even just under in common sense. Now, the issue, Justice Masipa, is that we allege that, therefore, Justice Downer, Mr. Downer or Advocate Downer sanctioned, by omission, sanctioned or authorized, and in fact he did more than that. It could have been that he just kept quiet and didn't go to the police or whatever, but he actively participated. He's the one, after all, on the 10th, who then told Mr. Breitenbach that I've now signed the document and so on. So again, in the criminal trial, of course, he's going to testify. He can say, oh no, actually Mr. Breitenbach, I don't know, told me that he had the authority of the NDPP. I mean, I don't know. So, but there is no, as we're sitting here now, there's nothing that absolves him from the responsibility he had to act in terms of the guidelines and either report or act on. As I say, when they are all, fortunately, all of them are witnesses. Mr. Breitenbach is a witness, Mr. Downer is a witness. And that's what happens in every criminal trial. We all think it looks like this, somebody fired a shot, therefore they are guilty of murder. And when they go to court, they say, no, it was self-defense, whatever. That's not for this court. That's for the other court. The simple question before this court is prima facie on what we have here. Is there this lack of authorization? Is there this condonation, sanctioning, authorization, whatever you call it, by the mere fact of non-action? If the answer is yes, that's it for prosecution. Whether he'll be found guilty or released in terms of Section 174 at the trial is of no concern to this court. So I hope that is behind us. What is it that we are really accusing Mr. Downer of having done or failed to do? Yes. Now, what makes it even worse in this particular case is that there is no world in which Mr. Breitenbach could have been authorized to do what he did. Even the lame excuse made by Mr. Downer that somehow deputy directors can do certain things under certain conditions, interact with the media, what have you, which doesn't apply here really. He should have known, or ought to have known, that that can never apply to Mr. Breitenbach, because Mr. Breitenbach is neither an NDPP or a deputy public protector. So he knew. That's called an act of association. That's what happens when you go in a bank robbery and your only role is just to drive the getaway car. You don't even get inside the bank. You just sit outside and drive the getaway car. You are charged together with all those who participated in the crime. You can't say, no, it's this one who took the money, it's this one who pointed the gun, it's this one who gave the teller the note. I mean, I was just waiting outside in the getaway car. No, it doesn't work like that. Which takes us to, with the greatest respect, my lord and my ladies, again, I've said the earlier point about conflating confidentiality, publication, and disclosure is a big point. But they don't come bigger than this point. The other wool that is pulled over your eyes, or at least the attempt to pull the wool over the eyes of this court, which is disgraceful, by the way, just so that I get it out of my chest, is the attempt to say that, to tell the lie that when Mr. Downer or Mr. Breitenbach or anyone else in the NPA that we don't know about conspired to leak this document. At that point, the document was a public document. And Sanral, blah, 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 you get told Sanral, the Sanral case applies, and so on. It's a blue lie. Everybody knows that is not true. How do I do that? Because the documents themselves, again, I'm not relying on anything we say, I'm relying on what they say. You will see that the first thing they do, every time the story is told, even yesterday or the other day, Mr. Baler's friend, Mr. Badlander, said, let's deal with the chronology. And then he says the application was sent to Justice Kuhn, and at 1643, Ms. Mon requested Mr. Breitenbach to give a document. Then he says 3 minutes later, Mr. Downer sent it at 1646.
Mr. Breitenbach.
I'm sorry, Mr. Breitenbach, thanks, yes. And so on and so on. It was already a court document, says Mr. Badlander. It's not true. The document on the version of the of everyone. The first lie is this. It's another lie by omission. Because you'll see even in the affidavit, it starts like that. No, at such and such a time, Mr. Breitenbach, depending on who you are listening to, Mr. Breitenbach, Ms. Mon requested the document from Mr. Breitenbach, and then Mr. Breitenbach sent it to him. Firstly, this conversation, which led to the leak of this document, was not initiated by Ms. Mon. It's a lie. The conversation was initiated by Mr. Breitenbach. We only discover that when he makes the police statement. All along we're told Ms. Mon made an inquiry, a media inquiry, routine. All journalists make inquiries from all of us. No. Mr. Breitenbach, out of the blue, called Ms. Mon. Ms. Mon was minding her own business somewhere in Pietermaritzburg because he wanted to leak this document. He called her and said, the WhatsApp exchange. So when I say called, it includes the WhatsApp exchange. It's actually better because we may not know what was said in the on talking. So the WhatsApp exchange actually assists us. I'll take you to it now, but it goes something like this. Are you already in Maritzburg? Because it looks like there's going to be a postponement or whatever. The other one says, I'm here in Maritzburg. The next 2 or 3 minutes, he sends the letter which was sent to Justice Kuhn. The next 3 minutes, he sends the unsigned affidavit. Now, really, and they say, what are we talking about when we say it was leaking? In which world does a prosecutor, national prosecutor, phone a particular journalist, not the media, as they say somewhere? They say, no, then it was given to the media at 1640. No. It's given to a particular journalist for a particular purpose in a conversation initiated by the prosecutor. But here's the catch of all catches. Mr. Downer and Mr. Breitenbach tell us and Ms. Mon tell us that there was an arrangement made among them that please do not write your story in this document until the document is filed tomorrow. I'll take you to the thing. So everyone knew that the document will only be filed tomorrow. It was Women's Day on the 9th of August, 2021, public holiday. And therefore they say it's going to be filed tomorrow, obviously when the court opens. Now you are told stories. So on the 9th of August, it's known to everyone. In fact, again, one doesn't have to be a lawyer or a genius or anything to appreciate this point. Anybody will know it. You ask it in what we call a rhetorical question. If there was nothing wrong with publishing the document before it is filed, then why was that arrangement made? Why was it necessary to say to Ms. Mon, don't publish until tomorrow or until the document is filed? It's because everybody, including Ms. Mon, knew. That's what we call mens rea in criminal law. Everyone knew that it's not done. You can't publish this story until such time that the document is filed. So again, we have another confession, because that little arrangement on its own is a confession. Because nobody gives a document to a journalist and say, no, but don't print it until tomorrow because I must still file it. And then comes here in front of a court of law and say, no, the document was filed. If it was filed, then what was the problem? They know, and they know very well, they're just trying to fool this court and the public into I don't even know what to call it. It's worse than obfuscation. And that is where the rub is. Because, and remember, by the way, even if the document had been a so-called public document, that only goes to the issue of confidentiality and publication and so on, not the disclosure. The disclosure, we're way past that now. The crime has been completed of the disclosure. And Miss Mon, therefore, whether you look at it as information, which is section 46, yes, 46(1)(a), 41(6)(a), yes, thank you, 41(6)(a), or whether you look at it as the document, the hard document from Dr. Mdutjwa, which is 41(6)(b). It doesn't matter, because they breached all those separate statutes. And the document that makes this very clear and obvious is the well, it's three documents. It's the affidavit of Mr. Downer to the police, the affidavit of Ms. Mon to the police, and then the affidavit of Mr. Downer in the postponement application. I'll give the references now. But the court can, for now, just be assured that the version which is bandied about here is that, I think it's 270 of, sorry. The version is that Mr. So-called, sorry, Sandral, sorry, that the Sandral case applies because the document had been filed on the 9th, which on anybody's version. And let's put aside now that at 9 o'clock, 21:07, Mr. Tusini was the attorney, included the document. So when I was explaining this to my learned juniors, I said, for a minute, let's assume that Mr. Tusini's affidavit was sent at 1 minute past 12, just so that the dates can work here. But it doesn't matter which way you do it. You can either use that analogy, or you can say, let's look at everything that happened before 9 p.m. What happened before 9 p.m. is that the crime was completed because, to everybody's knowledge, the document had not been filed and should not have been used. Now, Mr. Downer, at least to his credit, attached the email which they sent to Ms. Griffin, that is the registrar of Justice Kuhn. And it says very openly that the document will be filed, quote unquote, tomorrow. And please, Ms. Mon even sends a message to say it will only be their version if I publish now. So please tell me when Billy, quote unquote, Advocate Downer, has filed the document. So there can be no doubt in anybody's mind, any neutral person, that it's what we call in law, in criminal law, knowledge of unlawfulness, which is a form of mens rea. It's dolus directus. But if you want to be kind, it's dolus eventualis. But it doesn't matter, it's dolus anyway. But I say it's dolus directus because the evidence of the dolus directus is the arrangement. Had there been not that arrangement, it would have been open to the accused to say, oh, well, we made a mistake of law. We thought it had been filed, even though it was just an unsigned document, uncommissioned. So it was not only unfiled, it was uncommissioned as well. But what is worse, justices, is that so-called affidavit was actually unnecessary. There's no, this was just a vehicle for the leaking of the medical document. When we get to the criminal case, we will bring evidence to show that, when we show the state of mind, we will show that this was an intended crime. Because Justice Kuhn, Justice Kuhn said this: I'm giving you a directive. The applicant, the accused, that is Mr. Zuma, must apply for a postponement and tomorrow, and he doesn't have to be there because he was in prison. He doesn't have to be there, and we made a concession. Before that, we were fighting because we wanted his rights to be present, which every accused person enjoys, to be respected. But we said, unlike all these insults about Stalingrad and what have you, we said, no, that's fine. He's in prison, there's COVID, we'll go on without him. In fact, when we argued in this room, the Section 106, 1H, he was not even here, because he, not even us, had made that concession to say it's fine, carry on with the matter, even if I'm not there. So there is that arrangement. Justice Kuhn then says we must apply. While we're busy applying making the application. We must apply. We are the ones who want a postponement. They put an affidavit, a nameless affidavit. I don't know what it is called. Nobody asked them to put any affidavit. To do what? We must apply for a postponement. And then they must do an answering affidavit, and then we reply. That's how that's what happens in all courts all over South Africa. I've never heard of the respondent in the application for a postponement being the one who gives an affidavit first. It's not done. It was just a subterfuge to channel the crime. Anyway, they send that so-called affidavit, which is unsigned, uncommissioned, unsolicited. And they know that it is not it is not a court document by any description. Now, a lot of heavy weather is made by them about the fact that Mr. Tusini, the attorney at that stage, sent the document the following in the evening. Well, again, that has got, firstly, let's agree that has nothing to do with the disclosure point. It might have something to do with the confidentiality point, which is, as I say, aggravation, a matter of sentence. Because I can understand at the end of the criminal case, if Mr. Downer says, okay, don't give me 15 years, give me 5 years. He might say, look, insofar as the document was wrongly disclosed, then in any event later it was revealed, and therefore I must not be treated like the worst kind of criminal who has. That's fine. We'll deal with that when it comes. But for now, when we are only talking about whether there's a prima facie case of liability, that fact is mightily irrelevant because it goes to aggravation or confidentiality or publication. I've already made the submissions that the publication was not necessary. She might even not have published it at all. Aha, let's go there. Judge Kuhn does not disagree with me. That is wrong. That's another subterfuge that is pulled over the eyes of the court. Go to paragraph 240 of Judge Kuhn's judgment. You'll find it at page 147, I think, of the current one. Sorry. Yes, it is the current one. I think it's 147, my lady. Yes. Page 147. It starts at, it's K149, sorry. Starts at, it's KM17. It's an annexure to the founding affidavit of Ms. Karen Mon. And you'll find what they say is that point, let's call it res judicata point. So they say, no, this was decided by Judge Kuhn, and not only that, it was decided against us. Well, let me tell you something. At least if Mr. Tsengov was here, he would tell you what I said standing here. I said, on the 22nd, I think it was the second day, on the 22nd of September, standing here, I said, my Lord, we want to bring to your attention this matter that there's been a crime that has been committed, and Mr. Zuma, my client, in absentia, intends to prosecute around it, because section 41, 6, and 7 of the NPA Act makes it a crime. Justice Kuhn, who was a good and exemplary upholder of justice, at least in that respect, he says it here, and we appreciate that even where we differ with Justice Kuhn, where we appeal against him, we have never said that he did anything else than making an error, because we are all human. This is what Justice Kuhn says. He actually says the opposite of what you're saying, Malid. He says, I'm not deciding this point. 240, I said, which is at page 239. 240, the paragraph in the judgment. You'll see the previous paragraph, he quotes section 41, 6 and 7, the one I said, no person may disclose, and so on and so on. Then he says at 240, as the complaint was only made in argument and then in reply, an argument by me, which is what I've just told, and then in reply dealt with by Mr. In reply, yeah, it's still by me. Mr. Downer did not have an opportunity to respond thereto. I accordingly did not have the benefit of the issue having been dealt with fully in argument. In those circumstances, I consider that it will be improper to consider the request for any such referral further in this judgment. Let me pause there. What we were asking for there was to say, please, Justice Kuhn, in your judgment, we know that this thing has just arisen now in reply, but in your judgment, please add an order that says this thing must be referred to the NPA for further investigation. And he says, no, I can't do that because Mr. Downer has not had a chance. Then he says, apart from the procedural difficulty, I have doubt, that's not making a decision, whether the wide terms of 41.6 are necessarily constitutional. So he raises a whole different point, which is not raised in this matter, about the constitutionality or otherwise of 41.6. Does not arise here. That's the point that Mr. Masuku was making about, and Mr. I don't know if Mr. Ngalona touched on it, about subsidiarity. That if one of these parties, and there are so many amici and all sorts of people here, if one of them had come and said, look, maybe this situation was never envisaged. This section is unconstitutional. It should have a clause that says no person except a journalist doing his or her job and may disclose to any other person. But when it says no person, it breaches the Constitution and so on and so on. So that's what Justice Kuhn was trying to say here. And I'm sure he was hoping that someone will raise the point. So it's even worse than Obita. He's just talking, but you'll see how he described it. In case it looks like I'm being unfair to him, you'll see how he described it himself. Then he says, what is prima facie view, and so on. And then here's the other part. I would have thought, I mean, this is the kind, he's just chatting. Yeah. I would have thought that Section 41.6 would not, would not, for example, prohibit a member of the NPA, listen to this, in response to inquiries from a journalist. See, because he had also been hoodwinked to think that there was an inquiry from a journalist. He didn't know that it was initiated by the NPA. Yeah. To confirm or deny that a particular suspect might not be formally indicted, in particular charges, or the assistance regarding a particular investigation in another jurisdiction was being pursued. Continues with this speculation. But here's the killer. But these are simply ruminations without the benefit of having heard considered argument. If it is believed that the provisions of Section 41.6 outlaws such conduct, then a formal charge in that regard can be pursued, where the proper application of Section 41.6 can be fully ventilated and its proper interpretation determined, according to Ndumeni and according to Section 39 of the Constitution. So to use this to say Justice Koen disagreed would really be to take it too far. But I don't blame your ladyship. That's what is the finder that is being played here to make the court to believe, because that's one thing. The first thing Ms. Mon and Mr. Downer say this: we don't know what is going on with Mr. Zuma. Didn't you hear that Justice Koen disagreed with this? That's the extent of the so-called disagreement. Ruminations, chit-chat, speculation, maybe if it's unconstitutional and so on. Really. And again, to Justice Koen's eternal credit, well, maybe I should say Mr. Masuku's credit, because he drafted that part. The issue that I've been at pains to explain here, that the 41-6 matter is different from confidentiality, is clear from the judgment of Justice Koen. You can go to page 236. You see the heading there. It says Mr. Downer's alleged leaks to the media. So it deals with the issue of the leak, which is what 41-6 is about. Separately from the other heading, which you will find at, in fact, it's even intercepted by another point. But if you go to the issue of the confidentiality, it deals with unlawful attempted examination and so on. Sorry. Oh, yes. Page 241, paragraph 246, you'll see the heading there, the leaking of confidential medical information. So he makes it clear that these are two different grounds. There's the leaking, which is what brings us here. Then there's the issue of the medical information, which is a separate point, which has nothing to do with the crime, but is a, as I say, at best aggravation or a basis for the injury suffered. But I'm afraid I have to explain how we interpret laws in South Africa, which is contextually and in terms of the Constitution. So 41-6, not only do we have endumeni, not only do we have, because this is a statutory crime, this book called the Constitution says that at section 39(2) of the Constitution, when interpreting any legislation, when developing the common law or customary law, every court, including this one and any other court, tribunal or forum, must promote the spirit, purport, and objectives of the Bill of Rights. And those spirit and purport is explained in 39(1) as promote the values that underlie an open and democratic society based on human dignity, including the dignity of former President Zuma, equality and freedom. So the court actually has no option in this. This court has to interpret 41(6) and infuse into it the values of our Constitution, which includes the protection of the human dignity of former President Zuma and not leaking of his documents. And the purposive interpretation, which I started with, says that the purpose of that section 41(6) is to ensure that it gives the harshest punishment to anybody in the NPA who is guilty of this, or anyone else who aids and abets the commission of that crime. But let me just move to something else, which is this. Assume everything I've said is wrong. Everything. What the other side does not respond to is the fact that we have another count. We have another crime. Mr. Downer has proven himself to be a serial leakist. He leaked the documents. He leaked them 14 years ago, or however, it doesn't matter how many years. He did the exact same thing, my lord and my ladies, in relation to a journalist in the Mail and Guardian called Mr. Sam Soul. So all that has happened now is just removed his Mr. Sam Soul with Miss Karen Mon. The journalist that he used to leak, and this is a separate charge, is Mr. Sam Soul of the Mail and Guardian. And Mr. Downer, the same Mr. Downer, go to page 109. Sorry, I think that should be 109 of Downer. Sorry, I'm sorry, my lord. Yes. 109 of Mr. Downer's bundle. This is the good thing about all these things is that Mr. Downer puts them himself in these papers. Mr. Downer, this is a conversation he had on the 5th of May, 2008 with Mr. Soul, a prosecutor in our democratic republic. Look at conversation 2, you'll find that at 110. I'll just read it for context. Hello, this is Mr. Downer. Soul. Billy, Sam, can you talk? Mr. Downer, hello, Sam. Yeah, sure. Soul, listen, we got pretty good information that the Germans are in the process of striking a deal with Tyson in Germany. Mr. Downer, right. Probably next week or within the next 2 weeks and so on. And then the next page is, we've written, Mr. Downer now, we've written to them and told them that we know this is going on. I was just gonna say you need to extradite. Thanks. We got that info from Richard Young as well. Now that is a crime. He says he's giving information that belongs to the national prosecution. And that's what info means, information. Says we've written to them, that's number one. We've told them that we got this is going on. I was just going to say you need to extradite. And then he said, thanks, we got that info from Richard Young as well. In other words, I'm confirming this info that you are those three aspects. Okay, so that's the first part. But it gets worse. Go to page 111. This is Mr. Downer. BAE new investigation has to be declared. New terms have to be assigned. In respect of the Germans, the terms of our 2002 declaration of investigation include the whole of it for them, not to be declared ongoing since 2001. And here's the catch. But you can't quote me to say that. This is a prosecutor innocently doing his job. If he's innocently doing his job, why is he saying in secret, but you can't quote me to say that? He's leaking. Says, no, I'm not going to quote you at all. There's the deal, done. Then he says, it goes on, say that ongoing investigation on SA side. Let me just speak. You know what's happening here? It's not just leaking. It's what we call in the media industry. I used to work in it. It's not just leaking, it's coaching. You leak information to the journalists and then you coach them how they must even report it. So he says, say that ongoing investigation on SA side. In other words, Germans may have dropped theirs, but we haven't dropped. You can refer to the terms in the 2000 investigation. Formal terms of reference include in there. I didn't know, listen, we must sit down. Quite a lot of stuff that I can share with you. Right? And then it gets worse. And then he says, this is more information at page 112. Incoming requests in terms of Section 7, all the DG is to do, if done in terms of Section 7, is to get the minister's consent, send to magistrate. All magistrate can do is to issue subpoenas. In terms of that whole process, the investigation has been carried in South Africa, is very limited. People have been called in front of a magistrate and have been asked questions. That subsidiary process of triggering South African investigation is done as an exchange of info between the investigation agencies. And then Samsol says something about incoming requests and so on.
Are you reading this to show that he's been leaking information to Samsol, or just generally that he gives information?
No. I'm reading this because in the indictment of these two accused persons, there is a count, I think it's count 3, which relates to this crime that I'm dealing with now. All right. Now, which, by the way, the NPA said we don't have to look into this. That's all you have. Then it's the NPA which employed him. Then on the 18th of June 2008, this is what it says. There has been, at the bottom, sorry, there has been a formal request for a joint investigation. Billy says, yeah, but just avoid the terms joint investigation because the minister hated it. That's another coaching. So when you write a story, you must avoid the term joint investigation because the minister doesn't like it. And then on 114, I'm just taking selected spicy parts. And 114 in the middle, it says, I'm sure that person gone to trouble. I think that's Samsung. Then Billy says, be careful how you word it. Avoid sources close to us. In other words, be careful how you source it. Avoid sourcing it to the NPA.
My Lord, I'm sorry to interrupt, but last night when the learned friend telephoned me about arrangements for today, and he undertook that he would be done by 3 o'clock so that we could have an hour in reply. It's now 3:10. He also repeated that this morning. I'm concerned that we are not going to have an opportunity to reply.
Yes, no, that is true, my Lord. Firstly, no, I'm not about to finish. It's right what Mr. Padlender has said. Firstly, I had said in the morning that it was our intention to do so. But as I said, that was based on mainly the time that was left. We've already had, I think, the 10 or 15 minutes extra for the tea and another 15 minutes for the lunch. I don't know. Well, I can't. All the counsel in this matter, nobody has been they argued until they finished. Even the amici, they argued or dealt with the matters that they dealt with. I said myself voluntarily this morning that we are going to. I said voluntarily we're going to try, and which is why I phoned my learned friend last night, because there's nothing worse than having a matter not finishing. That's why I called him last night. I said we will try to do it within that period. But I'm not a prophet. I didn't know that will be half an hour.
He said we will finish by 3 o'clock, I promise you. That's
yes.
what he said.
No, that is true. But did I also say the lunch is going to take 15 minutes over and the tea will take 15 minutes over?
No, you didn't
I'm
say
not a
that.
prophet.
You didn't say
All right. Sangoma. All right. So the I was at page 114.
So I do need to record. My learned friend began this morning by saying we argued all day yesterday. We did not. My learned friend, Mr. Budlander Senior, and I finished shortly after lunch. The amici then began, and the two amici supportive of our case ended at 3 o'clock. I checked my watch. That means that there has now been a full day of argument by my learned friend, Mr. Mpofu, supported by my learned friend, Mr. Ngilwana. On any fair reading, my learned friend has exceeded his time. And what we cannot, and with respect this court should not allow, is for my learned friend to filibuster so that we get to the end of the day and this proceeding is prolonged. And we must insist with respect that my learned friend indicate how long he needs so that the court can make a ruling. Because my learned friend and Mr. Ngilwana have had since 3 o'clock yesterday until 3:10 today, that is a full court day. I beg your pardon. No, and Mr. Ngilwana, who was the amicus who began at 3 o'clock yesterday. Because if we're counting amici for their sides, then fine, we finished at 3, and they began at 3. But with respect, it is now more than a full court day.
My Lord, we're just wasting more time to try and save time, which is ridiculous. Firstly, Mr. Ngilwana, the first thing he said when he stood up here was that he's not on anybody's side.
Mr. Mpofu, I need you to indicate how much more time you require.
Yes. Well, I need the half an hour that I did not know was going to be. Sorry. I'm sorry. I'm just checking my time so that I can give you a proper answer.
Give you half an hour. It's insufficient time for it. I must ask you to wind up your argument now. Please.
Now. Okay. No, I thought I must stop now.
I didn't say you must stop now. Sit down. If you did not hear me ask me to repeat myself, I would gladly do so. I said I'll ask you to finalize your arguments now, so that we can have the other gentleman reply. I cannot give you a half an hour.
Well, my Lord, that's fine. I'll wind up, as you say. But I just want to record that it's unfair for me to have voluntarily, last night, called my learned friend and said we're going to try and finish at 3, and on the basis that the normal court hours are going to be kept and that we will start at a particular time. I didn't know that there's going to be half an hour extra that is unaccounted for. Yes, no, I know you've heard me, but I'm putting it for the record. Yes, so it's number one. Number two, no counsel here has been, first of all, no questions were asked from them, and therefore they were able to finish within their time. And don't hear me wrong, I appreciate interaction with the bench, because it's important to if a particular justice doesn't understand or wants to clarify a point. That's not what I'm not complaining about that, but I'm saying that does affect the time as well. So I was assuming that we'll have the normal time and also the same treatment as them. All right. Now, winding up, as I have no choice to. I think if this was meant to take me away from Mr. Soule's Mr. Downer's leakages, well, then it's not going to work. He then says at page 114, be careful how you word it. Avoid sources close to us. That's the leakage. And then at the bottom, I don't have any of those things to come from me. So, yes, this is Mr. Downer. I don't want, or whatever, there's a word missing there. I don't any of those things to come from me. Some of the things seem to be to first-hand information, as if he's quoting directly from section 41.6, where it says you may not give information. It must not come from me. They will ask who's talking to the Mail and Guardian. All right? So that is a separate crime, and anybody, even the most biased person, who can say that that does not amount to a breach of Section 41(6), then doesn't know what we're talking about here. Will he be found guilty in the trial? I don't know. But
it did not happen in our jurisdiction.
Pardon?
It did not happen in our jurisdiction.
All right. That will take us to Section 106 and 110 of the Criminal Procedure Act. Section 106, I think it's that what you've just said, my lady, is not an answer to the question whether there's a prima facie crime that has been committed or not. Yes, no, I'm just responding. May I? If in Section 106, 1H says the following, F, sorry, my lady. When an accused pleads to a charge, he may plead that the court has no jurisdiction to try the offense. Let's pause there for now. So, even if that what you've just said to me was correct, and even if this was a crime that's attributable to a particular city, thanks, that would be a matter to be raised at the beginning of the trial before the criminal court in terms of Section 106, 1F. Secondly, Section 106, 1F is the only exception to the rule. You look at Section 106, 4. Yes, 106.4. You know, I'm sure the court knows, as I've been told, that 106.4 can result in an acquittal. The only exception is if jurisdiction is raised. It says, an accused who pleads to a charge other than a plea that the court has no jurisdiction to try the offense, or an accused on behalf of whom a plea of not guilty is entered by the court, shall, save as otherwise expressly provided by this act or any other law, be entitled to demand that he be acquitted or convicted. What that means in simple English is that any other plea in 106 except the plea of jurisdiction is what we call a plea in abatement. In other words, it can be fatal. But a plea of jurisdiction is the only exception because it's dilatory. In other words, it doesn't mean you go away. If by some reason I take you and charge you in the Northwest where you did the crime in Durban, it doesn't mean you're going to get away with it. All that will happen is that the matter will be moved to the correct jurisdiction. And for that proposition, you must go to Section 110 of the Criminal Procedure Act. Section 110 of the Criminal Procedure Act says, where an accused does not plead that the court has no jurisdiction and it at any stage, after the accused has pleaded a plea of guilty or not guilty, or whether the accused has pleaded any other plea, and so on, and it appears that the court in question does not have jurisdiction, the court shall, for the purposes of this act, be deemed to have jurisdiction in respect of the offense in question. And where an accused pleads that the court in question has no jurisdiction and the plea is upheld, the court shall adjourn the case to the court having jurisdiction. So, in terms of Section 106 and 110 of the Criminal Procedure Act, to whether the thing was done in Durban and we're in Cape Town and what, the two things will happen. A, it must be raised. If it's raised, the court will be deemed, this court will be deemed to have jurisdiction. We'll argue it at that stage when it's raised in the criminal trial. B, if the court, if we don't succeed to say this court must assume jurisdiction, then this court will act in terms of section 110(2) and transfer the matter to Cape Town or wherever he says he was.
But then what you're saying is that would be raised in the criminal trial.
It will be raised in the criminal trial. That goes to our jurisdiction and prematurity point. But B, assume I'm wrong on that. Assume it can be raised here. It's, so what? It's dilatory at best. It will either be heard here or in Cape Town. Okay. Anything else about the issues? So that after that they ran out of lane, so to speak, because those are the only objections, except of course the one that I have to deal with in a hurry now, which cross both of them, the so-called Stalingrad. I don't think it's worth any the paper it's written on, except to the extent that I have to say this. Remember that in the Zuma case, in the SCA, we were accused here unfairly of having read the case in NDPP versus Zuma and stopped where it suits us, and you know, because we are such untrustworthy people, just without even talking. We were even asked to apologize, which we are not going to do, about stating that Mr. Downer is aided and abetted by his friends. Some of them, as Mr. Masuku said, those, at least some of them have come up to masquerade as his friends, but others not. And we're not going to apologize for that, because Mr. Badlander should know better. He's the most senior person here. He knows that what he did is not done. You don't do that for the cameras and stand up here and say your colleagues must apologize. We're not his children. So he knows that the rules are very clear. If there's any problem, that Mr. Badlander, anyone, either Mr. Badlander, if I see that there's a problem, I have a duty, professional duty, to raise it with them. It's in the guidelines of the LPC. And then to raise it here. I can't just stand here and demand an apology. What apology? It's not done. It's wrong. And it's unprofessional. But anyway, apart from the fact that whatever I was supposed to apologize for is not a matter of apology. We are representing a person here. We're not representing our jackets. Every document you see here has been sanctioned by our client. We painfully do that, even though he's in the middle of nowhere. Make sure that all the documents, he has looked at them because of his status in society. Anyway, it is said that in the safest place to get this, my lords and my lady, is in Mr. Ngalwana's heads at page 3. It's the case we all know, the case of NDPP versus Zuma. But you'll see why I'm using this, because Mr. Ngalwana has quoted the paragraph that we all quote, and then he also quotes the one we're accused of hiding. So, paragraph 37 of the judgment of Haram's DP says, a prosecution is not wrongful merely because it is brought for an improper purpose. It will only be wrongful if, in addition, reasonable and probable grounds for prosecuting are absent. something not alleged by Mr. Zuma and which in any event can only be determined once criminal proceedings have been concluded. Hallelujah. That's what we've been saying all day. It can only be determined at the criminal proceedings, but in any event, it is if there are no probable grounds. I've read from Mr. Soule's conversation, I've read from the affidavit, I've read from the emails to show that this is not a case where you can say probable grounds for prosecuting are absent. By any stretch of the imagination, no person can say that. And it says the motive behind the prosecution is irrelevant because, as Schreiner J.A. said in connection with the arrest, the best motive does not cure an otherwise illegal arrest, and the worst motive does not render an otherwise legal arrest illegal. The same applies to prosecutions. That's our law. And we were told that we stopped there because we are probably also, we look guilty. We didn't read the next paragraph. Well, the next paragraph is on the next page. This is what it says this, paragraph 38. This does not, however, mean that the prosecution may use its powers for ulterior purposes. To do so would breach the principle of legality. The facts in Highstead and another whatever, the police had confiscated machines belonging to Highstead. The object was not to use them as exhibit. They had enough exhibit, but to put Highstead out of business. In other words, the confiscation had nothing to do with the intended prosecution, and the power to confiscate was accordingly used for a purpose not authorized by the statute. This is what ulterior purpose means in this context. That is not the case before us. In the absence of evidence that the prosecution of Mr. Zuma was not intended to obtain a conviction, the reliance on this line of authority is misplaced and was the focus on motive. This is exactly what we're saying, that unless you can show that Mr. Zuma has no intention of securing a conviction for all these crimes perpetrated against him, and the sole purpose is the so-called ulterior motive, then you can, that's what the court said. Why would we not read this, bad as we are, when it actually assists us? And secondly, that qualification, even if it applied here, would not apply because this is a private prosecution. The principle of legality, which is to do so would breach the principle of legality. The principle of legality applies to public bodies. And we were told, wrongly in my respectful submission, but that's a matter that will be determined by the Constitutional Court, because we have appealed that judgment in Gauteng directly to the Constitutional Court. That's how strongly we feel about it. But in that case, here, well, I don't have to hand it up. Your Lordship said you've got it. In the Gauteng case, you'll remember that it was said there that the reason why it's called a private prosecution is exactly because it is private, and therefore the outer principle does not apply. So when it's President Zuma going to the Gauteng court and saying, they want to stop my prosecution, but to do so, they must pass the outer test because they are actually reviewing. They say, no, but outer test, who do you think you are? You are just an individual. Outer test doesn't apply to you. Let's go. The president cannot come. But here, he's now told, no. The principle of legality applies to you. What is that? What is that? It is not justice, at least. It's Zuma law. And we're not here for that. We're here to ensure that the same standard, the goddess of justice, must be blind. And if we're going to have justice that has eyes here, that determines who is the accused today, who is the prosecutor today, and then the law changes according to that, then woe unto this country. And you know, the members of the public are not stupid. Members of the public know when there's an injustice. They know it. They might not have gone to university like me and my learned friend, Mr. Masuku, and everything, but they know when there's an injustice. When somebody is incarcerated without having stood in a court of law to say, am I guilty or not guilty, then they know, they say, this far and no further. Anyway, at paragraph, yeah, well, at page 162, sorry, my lord, I'm sorry, my lord, I'm trying to fight fires here. Yes, my lord, I'll come to that. Just let me just make this one point. I won't even read. I'm just making a reference. If the court can go to page 162, of the MON documents. Is it? Okay, let me just make sure. Sorry, man. It's 162 of Downer, sorry, of the Downer document, yes. It says, it's just the exchange, and I'll just read it, I'm not going to develop it, in the same spirit as the conversation with Mr. Soul. This is the email exchange on the day in question, when the crime was committed. Sorry, I say email, WhatsApp, yeah. Mr. Breitenbach, I hope you are well and aren't en route to PMB, Pietermaritzburg. That's at 1639. I'm here, 1642, that's Ms. Mon. 1644, 2 minutes later, boom, he sends the Kun J letter of August 2002. There's nowhere where Ms. Mon says, I request a document, all the lies that I told in this affidavit, that she made a request for documents. Sends Kun J letter. 1646, he sends the Zuma postponement affidavit. And then in the morning, 7:29, sends our affidavit. And then at 7:30, she says, thank you. And then she says, when can I publish this? And then he says, it was emailed to the judge's registrar and the parties last night, so you can do so now. That's what's called knowledge of unlawfulness, mens rea. So he says, because it was emailed to the judge's registrar and the parties last night, and this one was signed, you can do so now. It's wrong in law, but at least it's an attempt. And then she says, thank you. And she says, great. And then she says, I need to wait before I file on Billy, though. In other words, this file now is about filing the story. So she has to wait on Billy before she can file the story. So the story is written on the criminally obtained information, but she has to wait for Billy. Then Mr. Breitenbach says, I'll check with him. If that's not an act of association, nothing ever will be. And remember, he had been told before. And he says, please, otherwise it's just their side. In other words, I'll only be publishing theirs. And Tusini refers to Billy's affidavit. That is leaking information that is in your possession in terms of the NPA Act. And it is a crime in South Africa until that statute is changed. What I will do, no, I have to say this. The Ms. Mon says that they have two ulterior motives. Ms. Mon's ulterior motive is that Mr. Zuma wants to harass and intimidate her from reporting. She's reporting, she's been reporting, as Mr. Masuku said, ever since 2021. I don't know what intimidation. She writes every day on Twitter about Mr. Zuma. Nobody has done anything. The worst thing that she alleges is that somebody called Mr. Manyi, who is the spokesperson of the G. Zuma Foundation, not even in that capacity, as himself, as Mr. Manyi, just walking in the street, sent a tweet, and Ms. Dudu Sambutla Zuma also sent a tweet. I mean, really. So, former President Zuma must now go around controlling everybody out there, spokespersons and children, about what they tweet. I don't even, he is on Twitter. I was going to say, I don't even think Mr. Zuma is on Twitter. But to the extent that he is, he's not his daughter's keeper. None of us can be imposed with that silly obligation. So there's no intimidation, there's no... Mr. Zuma says, "Aigabi," as we say. He says, "I don't know the lady. I do not know this Karen Mon. In fact, he was saying to me, even if she came there, I wouldn't be able to point her. So how can I resent her as someone that I don't know?" I was told, I saw this thing and I was told that somebody is doing rounds with my information and so on, my medical information. I don't know the person. So this idea that by osmosis, whatever resentment might happen to anybody on Twitter must be attributed to President Zuma is just plain nonsense. Then the other Stalingrad version now of Mr. Downer is that, no, it is to get rid of him as a prosecutor because of the so-called 20 years Mr. Zuma has been evading. I don't know how I describe that one. Firstly, there's no 20 years. The so-called 20 years that gets bandied about, we allow this thing to happen because, you know, the media has got its own mentality. But in a court of law, you can't come and talk about the 20 years. There's no 20 years. The charges were withdrawn in a particular time. For 9 years or so, there were no charges, and then they were reinstated in 2018, I think, yes. So they count even the 9 or 10 years when there was nothing into this so-called 20 years. And then they lie and say that Mr. Zuma, in all that, he has been unsuccessful in his matters. Well, that's also false. Mr. Masuku has told us that Judge Msimang in this court said that this was politically motivated. Judge Nicholson in this court said that it was politically motivated. But if the answer is going to be, well, okay, they might have said so, but eventually there was an appeal and so on. But I'm just saying judges, sober judges of this country have held in Mr. Zuma's favor. But let's forget about all that. Justice Kuhn, here, sitting here last year on the 11th of April, when we wanted a postponement pending a Constitutional Court appeal, the other side came here and argued Stalingrad. Justice Kuhn rejected it and granted the order in our favor to await the outcome of the Constitutional Court, and rejected with the contempt it deserves, those are my words, he didn't say it himself, the so-called Stalingrad accusation. So people can go and manufacture their own facts out there, but not, this is a court of law, this is a serious place. It's not a place to come and bring gossip here and twisted spin. So there's no Stalingrad. If there's any Stalingrad, they are guilty of Stalingrad. Because as the Stalingrad is either the myopic version that gets described by the chartering classes out there, or the version that was described in a court of law by Wallace J.A. at paragraph 157 of the Moyo case, where he says Stalingrad is the tendency of well-to-do, well-resourced accused persons to escape the consequences of their actions in a criminal court and go to a civil court. That's Stalingrad. That's what they're doing. That's why we're here. They should go back, like all the people in this country, black and white. When they are served with a summons and they say, go to court on Monday, the criminal court, they take their things. It doesn't matter if they think that they are innocent. They go to court, they run the trial, they win or lose. What's so special about them? Why should they not deal like all the millions of accused persons every day in our country? and come here and have 3 judges at their request in a civil trial, listening to all this, instead of doing that which every South African is obliged to do. Forget about every South African. Former President Zuma, Mr. Downer says he's a prolific litigant or whatever, says that as a snide remark. No, it's not a snide remark. It's a badge of honor. Because unlike some, former President Zuma, for all the years, for every time he's here, day in, day out, if he has to be there in the dock, he's there in the dock. If he has to be sitting here, he's sitting here. He has never sheepishly run away from appearing in a criminal court of law. He is here. He's a former president. He's not you and me or you know. He's a former president of this country. But he comes here dutifully. If he's going to be sick, he sends a note. And for years and years, he's been doing that. But no, not Ms. Mon, not Mr. Downer. Let's be serious. If we want a country here, let's make sure that we have a constitutional democracy that respects the rights of every citizen, black or white, in the same way, and nobody should have some special dispensation of a civil court. That is what is Stalingrad, as described by Wallace J.A. in paragraph 157 of the Moyo case. And therefore, with the greatest respect, for the reasons that I've explained, I don't have time. If your Lordship, maybe just to, if your Lordship can allow us to, because there are 1 or 2 points, maybe to file a short supplementary submissions on the 1 or 2 points. Yes. Thank you, my Lord. As the court pleases. I'm indebted to the court.
Lord, could I have an indication as to how long we can argue? Because I will not be done in 15 minutes, and I'm afraid that what has happened here is that my learned friend Mr. Mpofu has argued from 9:30 until quarter to 4. That is in excess. That's approximately 5 hours without breaks. My learned friend Mr. Budlander and I argued yesterday from 9:50 until 12:30. That's 2 hours and 25. But with respect, my Lord, my learned friend Mr. Mpofu is not entitled to disentitle my side from a proper entitlement to reply.
Try to explain that to Mr. Mpofu as you heard it, and you saw what response.
Well, my Lord, in that case, we ask for leave. I can't speak for Mr. Downer, but we ask for leave to file our note in reply. Because with respect, there are points that need to be dealt with. There are arguments that have been made that are entirely without merit, and I would ask that we have permission to use the 15 minutes to go, and that we are then entitled to file a note in reply to Mr. Mpofu's address. That is, I make that request. Alternatively, I ask that you request that the court staff sit late. I make one of those 2 requests, my Lord.
That's, respectfully, I respectfully adopt the same position, my Lord. We really, it would be entirely unfair for us to be denied the right to reply.
My Lord, sorry, just a few remarks now that if that will be the arrangement.
No, with respect, my Lord, I did not invite my learned friend to address you again. I asked for the 15 minutes to address you, following which I would deal with the balance of the points in reply. And for him to suggest that he's now going to make further submissions is, with respect, wholly unprofessional.
My Lord. Thank you. 2 minutes. 2 minutes.
We're very grateful for that. We are most indebted to your lordship, your ladyships, and indeed the court staff. Thank you.
You want to say something, Mr.
Yes, my lord, I was on my feet, but Mr. Badlander chose to insult me. I was still on my feet, and he says my wanting to speak is unprofessional. It's fine. We'll tolerate these things up to a point. I just wanted to say that I don't want to be waylaid by that. Just to say two things. One is Mr. Badlander Jr., at least, Mr. Badlander Sr. is not involved in this, knows that this very thing that happened here happened in a matter where he was my opponent last month, and we couldn't finish a 2-day matter, and we had to come on a 3rd day. And that was arranged. Fortunately, he had finished, and he's junior.
Does this have anything to do with the time you allocated to them?
No, my lord.
Well, then please,
No, it does. No, my lord, I've been insulted. Your lordship cannot allow. I was told, firstly, that I'm filibustering, number one. And now, secondly, I've been told that my wanting to address the court is unprofessional. If your lordship wants to silence me in the light of those insults without giving me a right of reply that everybody who is insulted in this country has, then I will sit down. But thank you very much. Yes. Well, my lord, I was insulted in this forum. I'm simply saying that if I was told that I'm filibustering, the court did not intervene, which the court should have done. And the court did not intervene when it said that when I want to address it, it's unprofessional. Then what other forum am I going to address in?
You're now encroaching on the court's time, the court's gratuitous time. Thank you. We have more than enough time to address the court. And we've heard the submissions and we have read.
Well, my lord, I'm sorry. Sorry, my lord. Yes, no, that's fine. I just want to place on record that I did not filibuster and I did not act unprofessionally. And if anybody feels that I did, they, not me, must go to the appropriate forum.
So noted.
As the court pleases.
Thank you, my lord. My lord, I have agreed with my learned friend for Mr. Downer that I will argue first, and we will ensure that we do not repeat each other, and we will ensure that we complete within an hour between us, even if I take 5 or 10 minutes extra. My lord, my ladies, what you have been treated to is with respect a spectacle, because you've had to witness our learned friend for Mr. Zuma accuse this legal team and the other legal teams of lying, of being disgraceful, of being arrogant, of bigotry, of obfuscation, and of subterfuge. And I'm afraid that it became clear what was going on in 2 answers. When at one point your lordship presiding said to our learned friend for Mr. Zuma, we know what the law is on private prosecutions, and you were told, well, you are not the only audience. And later when there was an impassioned speech about members of the public. And I'm afraid that what you have been treated to is not a legal argument. It is a speech for purposes of television. And that is most unfortunate. It's unfortunate for 2 reasons, because what it...
Hello? I'm sorry, I don't want to interrupt my learned friend, but I just want to say, if there's going to be any further trading of insults, then we will require an opportunity to address them at the end. The submissions we made were aimed at the litigants. We never said anything about counsel, but were available if there's going to be that kind of insult. They're not going to be abused here.
Well, look, my learned friend took my next words out of my mouth. What I was about to say is that we are going to resist the temptation to respond likewise. We are going to do what we understand is our duty, which is we are going to focus on the facts and the legal principles at hand. Because with respect, when you focus on the facts and legal principles at hand, it is obvious that there is no defense here, and both applications fall to be upheld. So on that at least, my learned friend and I now agree, and I will proceed to deal with the matter as dispassionately and clinically as I can, and to avoid getting drawn in to what has become a rather muddy spectacle. So in that regard, my Lord, I propose to address 5 issues in the course of this reply. Firstly, I will deal with the question of jurisdiction and prematurity. Secondly, I will deal with the point of joinder, which is somewhat extraordinarily persisted with. Thirdly, I will deal with the noli prosequi. Fourthly, I will deal with abuse. And fifthly, I will deal with the injury. In other words, I'm dealing with 2 preliminary points, and then the 3 grounds on which we submit, on behalf of Ms. Maughan, the application falls to be upheld. Now, on the point of prematurity and jurisdiction, my Lord, my learned friend begins by saying that the constitutional founders, that's in his words, decided that criminal matters must be decided by criminal courts, whereas civil matters must be decided by the civil court. Well, with respect, my Lord, that's simply not correct. The Constitution doesn't refer to civil courts. It doesn't refer to criminal courts. It refers to courts, and in section 166 it refers to the High Court, which embraces both civil and criminal courts. So the starting premise is plainly wrong on any reading of the Constitution. But it's wrong for a different reason, my Lord. It's wrong for a different reason because the authorities on which my learned friend relies are plainly inapposite. My learned friend calls in aid 2 authorities: the Moyo decision of the Supreme Court of Appeal, which frequent reference was made, and the Tint decision in the Constitutional Court. Now, Moyo, my Lord, was not about this issue at all. What Moyo was about the issue that arises from time to time, which is, can one challenge a statute before that statute has been used against you? Can one proceed to court and say, this statute is unconstitutional because of what it criminalizes, because of what it does to you, because of what it requires for sentencing, or do you have to wait for the statute to be used against you? And the courts have given a range of different answers depending on the context. For example, in Centre for Child Law, and my Lord, perhaps to assist the court, if I could, instead of reading the full reference, I can just give the court a list of the references at the end without argument in writing. But in Centre for Child Law versus Minister of Justice, the 2009 decision of the Con Court, the court held there that a sentencing provision could be challenged immediately. You didn't have to wait for a child to be sentenced. And in Amabungani versus Minister of Justice, the court held that you could challenge RICA directly without having anyone dealt with under that. But in a criminal context, in 2 cases, the courts have expressed concern. Those are the 2 cases referred to this morning: Moyo versus Minister of Justice and Savoy versus National Director of Public Prosecutions. So the issue in Moyo was not about whether you could set aside an abusive prosecution, nor about which court you had to go to. It was about a different question. Can you challenge a criminal statute under which you are charged before you have been convicted? Justice Wallace seems to suggest no. The court in Savoy seems to suggest maybe, but it's very difficult. But it doesn't matter, because it's all entirely irrelevant. Ms. Maughan and indeed Mr. Downer do not seek to challenge a statute, and so the principle in Moyo and the principle in Savoy are of no assistance whatsoever. The second authority on which reliance was placed was Tint. Tint was a search warrant case, and there the debate was, should you be able to challenge a search warrant in advance and prevent evidence from being put before a criminal court in advance, or should you wait until the end of the trial? And the Constitutional Court said you must generally wait until the trial is going. That's what happened in Tint. We are not in a search warrant case. We do not complain, my client and indeed Mr. Downer, do not complain about fair trial rights. And so Tint is of no assistance. And similarly, the only other authority relied on by our learned friend is of no assistance either. That is the judgment by Mr. Justice Kuhn on the 106 issue. You will recall that you were told in submission that Mr. Justice Kuhn had given a judgment and had said that any allegations of abuse or to stay the prosecution had to be dealt with in the criminal trial. That is not what he said. What he said appears in paragraph 77 of his judgment. The court does not need to go there, but I will give the court the reference. What he said at paragraph 77, and it appears in the Maughan papers at page 180. What he said was, if there are complaints about any issue in the trial or fair trial rights, those can be revisited at the end. In other words, he applied the Tint principle. But no one has argued any fair trial infringement in this case. Ms. Morn hasn't, Mr. Downer hasn't, and so the reliance on Justice Kuhn's judgment is patently inapposite. So the three judgments which were put before you, purportedly in support of the jurisdiction point, the Moyo case, the Tint case, and Justice Kuhn's judgment, do not advance Mr. Zuma's case one iota. There is no authority cited in support of that case, which is on point. What about the authorities on the other side of the table, which support the idea that we are entitled to proceed as we have? Well, we have what's been described as the ancient judgment of Solomon, decided in 1950. Well, it was decided in 1950, long before I was born, but thankfully it has now been approved and cited with approval in Phillips versus Botha, the decision of the SCA, 1999. We've cited it in the heads at 565F. So Solomon is still good law under the constitutional era because it has been cited by the SCA. And Phillips versus Botha, in turn, was referred to with approval in Mineral Sands Resources by the Constitutional Court at paragraph 77. So is there any doubt that Solomon is still good law? No. So was Justice Sutherland and the full bench in Gauteng incorrect in following Solomon as it did? No. And you've heard no cogent argument as to why they are wrong. We're not going to argue that you're bound by that judgment. That's not necessary for us to do so. The bottom line is it's plainly right. It's right because it follows long-established principles and because the only authorities put up on the other side are plainly inapposite. One last judgment on this score, as if there were any need, but in the judgment dealing with the, in the full bench judgment dealing with the stay application in Mr. Zuma's case, the same issue arose. Because what happened in that case is that there were applications for a stay brought by Mr. Zuma on the one hand and Thales on the other. And one was brought as a criminal case and the other was brought as a civil case. And what happened as a consequence, and we will make that judgment available to you, but it's made clear in the judgment that one was a civil case, one was a criminal case. They were heard together. They were heard together in front of a bench of 3 judges in this division. And of course they were dismissed. And the 3 judges who heard that were Justice Nguni, Steyn, and Poyotlwati, as she then was. And when Mr. Zuma sought to appeal, he tried to run this very point. He tried to run this very point by contending, and it's summarized in the judgment on leave to appeal, that the complaint in this regard was that it was an irregularity for the criminal trial to be reconstituted and the application to be heard as a civil trial by a full court of the High Court, as this was contrary to the CPA. The contention was that the application should have been heard before a criminal court constituted as such. So the very argument that is raised here by Mr. Zuma was raised in an attempt to appeal against the judgment of the full bench and the stay application. It was rejected by the full bench, who refused leave to appeal. It was rejected by the SCA, which refused leave to appeal, and it was rejected by the Constitutional Court. So where are we on the jurisdiction prematurity point? On Mr. Zuma's case, no authorities on point, none whatsoever. On our case, a long line of authority dating back to 1950, approved by the SCA in 1999, and the recent judgment of the full bench in this matter. The jurisdiction point, with respect, and the prematurity point, and the subsidiarity point should be seen for what they are, a desperate attempt to avoid getting into the merits. Let's move on. The second point that is raised in a similar attempt to avoid dealing with the merits is the joinder point. The extraordinary point is made that Ms. Morn had to be joined by Mr. Downer, and that because she wasn't, the case is fatally flawed. Let me place on record what has already been placed on record. Ms. Morn does not wish to intervene or participate in Mr. Downer's application. There is no need for her to do so. She has launched her own application, and insofar as she had a right to be joined, she waives that right. I am mandated to place that on record. But we're then told that it's impermissible for that waiver to operate because Ms. Morn still has to be heard somehow, and the example is given of a tender case where you can't not cite the one tenderer because they agree. Well, that's what happens every day in tender reviews. Why does it happen every day in tender reviews? Because it has been our law since 1949 that a party with an interest requiring it to be joined is entitled to waive that right. That is the famous case of Amalgamated Engineering Union versus Minister of Labour. It will be on the list of authorities, and the reference is at 659. There, the appellate division, and this is even more ancient than the previous case, but it's been cited again and again and again. And there, the court said there may also, of course, be cases in which the court can be satisfied with the third party's waiver of his right to be joined, e.g. if the court is prepared, under all the circumstances of the case, to accept an intimation from him that he disclaims any interest or that he submits to judgment. It must be borne in mind, however, that even on the allegation that a party has waived his rights, that party is entitled to be heard. Well, you are hearing me with respect, my lord and my ladies. You are hearing me on behalf of Ms. Maughan, and she waives her right to be joined. Let's move on again. And it's notable with respect that so much time was spent debating those two issues, and the reason is palpable. It's because there is no defense on the merits. So can I now turn to the merits? And the court will recall that there were three different bases upon which Ms. Maughan impugned the summons. The first was the absence of the noli prosequi certificate. The second was the abuse of process doctrine. And the third was the absence of an injury. I'm going to deal with each of them in turn because each of them has not been fully answered and each of them is more than sufficient to set aside the summons. Let me begin with the noli prosequi certificate. Now, the argument on the first noli prosequi certificate is that when you read everything together, when you read the letter from the DPP, when you read this, when you take into account all of the context, you should conclude that the first noli prosequi certificate, even though it referred only to Mr. Downer, actually meant to refer to Ms. Maughan as well. But there are two problems with it. The first problem is that's not what it says. And so what you are asked to do under the guise of endumeni, which must be the most abused case in all cases that I've seen, it's cited whenever you need to get around some wording, is you're told ignore what it actually says and think laterally, and you'll find that it actually refers to Ms. Maughan. Well, with respect, that's not the way endumeni or any principle of interpretation works, and it is inconsistent with what was said by the relevant official in the letter which I took you to and which I will take you to again. It's in paragraph 18 of our heads, Advocate Zungu writing, "When I took the decision in respect of the aforementioned matter, the suspect under consideration, as expressed by the complainant, was Mr. Downer. Based on the investigations and the evidence, I declined to prosecute Mr. Downer. Ms. Maughan was not contemplated as a suspect." Now that, of course, explains why, and we now understand it, why Mr. Ntanga, in his supplementary affidavit, was at such pains to suggest that Ms. Maughan gave a warning statement, or Ms. Maughan gave a statement to the police. And our learned friend for Mr. Zuma said again and again and again that Ms. Maughan gave a statement to the police. He's trying to squeeze her into the suspect category. But she didn't with respect. And I explained that painstakingly with reference to the facts in my opening address. The facts are she was asked for information, she took legal advice, and she volunteered to give an affidavit to the NDPP. It had nothing to do with the police. I took you through that. There is no answer to that. And so the premise on which it's built, that Ms. Maughan was somehow a suspect, is patently bad, and that argument must therefore fail. So with regard to the first issue, the question of whether Ms. Maughan was mentioned by the first certificate noli prosequi, the answer is she plainly was not. And that is the end of the matter. Because whatever the second certificate says or doesn't say, I argued to you that the certificate noli prosequi is a jurisdictional fact. It had to be in place before the matter began. I pointed you to the authorities in that regard, and there was a deafening silence from our learned friend for Mr. Zuma. Absolutely deafening. You did not hear argument to the contrary, you did not hear authority to the contrary, and what that means is, when this application was launched by Mr. Zuma against Ms. Maughan, and the certificate was not in place, then it was invalid. And that is the end of it. So you don't need to concern yourself with machinations about what the second certificate means, because on the only legal argument before you, without the first certificate being in place, that was the end of the matter. I say again, as I said to you in chief, we could all go home now in respect of Ms. Maughan, because there was no answer to that proposition. That would be the end of the matter. But instead of going home, which I hope we will all do shortly, let me move to the second point, which is the abuse of process. Now, I began on the abuse of process by making 2 points on the principles. And I said that 2 principles were undoubted in our law. The first is that motive was relevant, despite the arguments relying on Mr. Justice Hurrams. And the second is that the merits were relevant. And both of those, I said, were established by the Mineral Sands Resources. You heard no answer to those. So you can now accept that notwithstanding what is said in the heads, notwithstanding what is said in the papers, you can accept as a matter of law that motive and merits are relevant to abuse of process. And that must be so, because that is the law. So can we now turn to deal with the different grounds on the abuse of process? And can I begin with the one on which our learned friend spent the most time? And that was a desperate and with respect, somewhat valiant attempt to persuade you that there actually is a case on the merits here. That actually somehow, if you look askew, you will find there is some case on the merits against Ms. Moore. And this, with respect, at least I will say this is the first time that we've actually had that argument. There's nothing in the heads on that. I made that point to you. This is the first time that we've had an argument which says this is why Ms. Moore and Mr. Downer are guilty. So we are at least making progress, but with respect, the argument is wholly without merit, and let me demonstrate why. I now understand what Mr. Zuma's argument is on the score. Mr. Zuma's argument is that Section 41.6 of the Act must be given an absolute meaning. When Section 41.6b says that no person without the permission of the NDPP shall disclose to any other person the contents of any book or document or other item in the possession of the prosecuting authority. Mr. Zuma's case is it means any book, any document, any item. That is the argument our learned friend advanced with great vigor. His argument is that it does not matter whether it is the letter from the doctor, whether it is some other document, it's automatically a violation of 41.6 if it's disclosed without permission. And in fairness, when you read the statute by itself, there might be something to be said for that. But the problem is that, as you heard again and again from my learned friend, for Mr. Zuma, that is no longer how we read statutes. I lost count of the number of times you were told that you had to interpret the statute in context and subject to 39.2 of the Constitution. And on that at least, my learned friend and I agree. The problem for my learned friend and his client is that when you interpret it in that way, his whole argument falls apart. And let me demonstrate that by means of an example. Let's say that the document that Mr. Downer has in his possession is not the letter from the doctor. It's a copy of the Criminal Procedure Act. And Ms. Moore is reporting on a case, and she goes to Mr. Downer and says, Billy, I'd like to borrow your copy of the Criminal Procedure Act, the one that was paid for by the NPA. Please could I do so? I've left mine behind. And Mr. Downer gives it to her, and she writes a piece disclosing it to her members. On Mr. Zuma's argument, he has committed an offense, because that is a document in possession of the NPA. He has given it to Ms. Moore without authority, and he's committed an offense. Or suppose she says, Mr. Downer, I believe there was a judgment that came down yesterday. Why don't you give me a copy of it? And Mr. Downer gives her the copy, and she writes about it. That would be a breach. Now, I see my learned friend laughing, and I'm glad he finds it amusing, because it's so patently absurd that it could never be what the section means. The section is not about every piece of paper that happens to be sitting in Mr. Downer's briefcase, or every document that is sitting on his computer, or every document in his filing cabinet. It is about something else. It is about a document that has not been disclosed to the public, has not been made public, and that has some air of confidentiality. And that's obviously what it's about. Why do I say that's obviously what it's about? Because that is what the SCA told us in the decision in Maharaj versus the M&G. Now, this was not cited in our heads because this is the first time we've been furnished and favored with this absolutist argument. We will give the court, again, the reference. But in Maharaj, the court had occasion to consider exactly the question of how one dealt with Section 41 of the NPA Act. That case was about a Section 28 inquiry. I don't need to deal with the details. But what the court said, and if the court would make a note, I'll give you the full reference on my list of authorities, but what the court said, and if the court could have regard particularly to paragraphs 31 to 34. In paragraph 31, the court said, and the debate was, where there had been a Section 28 interrogation, which is expressly subject to 41, and the MNG was in possession of it and wanted to publish it, would they be committing an offence? Did the NPA have a proper basis to resist? And the court said at paragraph 31, the information in question was already largely a matter of public knowledge at the time the NDPP made her decision. To the extent, therefore, that the interests of others, read Mr. Zuma, would be implicated, there was no longer any basis for confidentiality inasmuch as the information was squarely in the public domain and had been for some time. And then in paragraph 32, where the NPA had said we have to rigidly adhere, never to give you anything in our possession, the court said the NDPP's rigid and inflexible adherence to the policy of non-disclosure meant that she completely lost sight of the fact that the appellants had themselves placed the evidence in the Section 28 proceedings in the public domain. They did so when they annexed the relevant transcripts of their evidence to the court application challenging the constitutionality of certain provisions. As this court observed in Van Breda versus Media 24, a judicial proceeding is a public event and information on the public record may be broadcast despite its highly sensitive nature. And the court cites Van Breda in the SCA. And then it says in the next sentence, in Cape Town City versus Sanral, it was pointed out that the animating principle, therefore, has to be that all court records are by default public documents that are open to public scrutiny at all times. While there may be situations justifying a departure from that default position, any departure is an exception and must be justified. And then at paragraph 34, the same point is made. So, what the court explained there, to use my learned friend's words, is that a purposive approach to Section 28, to Section 41, is that it is not intended to cover information which is in the public domain. Self-evidently. Self-evident. But if there were any doubt on that score, let me assume that you are somehow troubled by that conclusion. I don't know how you could be troubled, because with respect, it's obviously a confidentiality provision. But if you were somehow troubled by that provision, we would commend to you the decision in Democratic Alliance versus ANC at paragraph 129. That's the decision of the Constitutional Court, where the Constitutional Court laid down in words of one syllable how you interpret harsh penal provisions, harsh criminal provisions. Because you heard at length from my learned friend how strenuous the punishment was, the 15 years, the seriousness. Well, what did the Constitutional Court say in DA versus ANC? It said when you're interpreting these kinds of provisions, these are tough provisions, very tough. They show the statute's prescriptions have meaning, and they could operate with calamitous effect on any party who falls foul of them. These considerations point to how we are obliged to approach the interpretation of the provisions. In case of doubt, we are obliged to interpret their prohibitions restrictively. This means that we must resolve any ambivalence in them or uncertainty about the meaning against the risk of being penalized. So even if you read M&G and Maharaj, and you read the sections and you apply logic, and you still think to yourself, does this provision apply to court documents? You would apply the test in DA versus ANC, and the answer with respect is obvious. How could it ever be constitutional or appropriate or intended by Parliament to penalize someone for disclosing a document which was already a court document and was therefore open to the public? Now that is the end of the case, because what that means is that Section 41 has no reach to documents which were filed in court. And my learned friend did not disagree with the chronology which I took you to about how the matter occurred. There was no debate that the first time the letter was sent to Ms. Maughan, it had already been sent to the judge for purposes of the proceedings. And the first time it was published by Ms. Maughan, it had already been sent to the judge 3 times. Once by Mr. Downer, twice by Mr. Downer, once by Mr. Zuma's legal team. What are we still debating with respect? Unless there is going to be a serious argument that a court document cannot be disclosed without facing 15 years imprisonment, this case is non-existent. It is a mirage. And that's without even getting into the debate about whether it was Mr. Breitenbach or Mr. Downer, which I don't propose to get into, because it doesn't matter. It just doesn't matter. So where are we on the abusive process? Well, on the merits, the case is not just weak. It's hopeless. It's non-existent. It is a mirage. What about the other points that we made? Mr. Zuma's personal animosity to Ms. Maughan. Well, you're told Mr. Zuma doesn't know Ms. Maughan and wouldn't recognize her, but he was prepared to describe her under oath as being a racist bigot. With respect, I didn't say he knew her and his views were justified. I said he had animosity to her. When you call someone a racist bigot under oath, that normally classifies as some degree of animosity. Was that 5 more minutes? Thank you, my lord. Mr. Zuma's true purpose in bringing the private prosecution, well, I've said all I can about that. The suggestion that Mr. Manyi is somehow distant from Mr. Zuma when he's speaking on behalf of Mr. Zuma's foundation is simply extraordinary. We've made our point. I don't need to make anything further. And lastly, on the question of Mr. Zuma's attempt to mislead this court, you've heard nothing. We argued in great detail on the basis of the replying affidavit that Mr. Zuma's annexure put up to say that Ms. Maughan had deleted the tweet and that this was evidence of a guilty mind was false, that it was manufactured evidence, and that it was an attempt to mislead the court. There was no further affidavit, despite what is said in the Competition Commission case, which will be part of the list, and there was nothing in response. Nothing. Not a word. And it's no answer to say that my learned friend ran out of time. He didn't run out of time, and I would have thought that given the importance of this issue, it would have been worth addressing well within the first 5 hours of his address. So where are we on the abuse? We have a meritless case, utterly, utterly meritless, brought against a journalist who has reported critically on Mr. Zuma, who bears a personal animosity to her, and who attempts to mislead the court to show that she has a guilty mind. I say again, if there is no abusive process in this case, then none exists. The last point on this before I turn to the injury, the suggestion somehow by our learned friend Mr. Ngalwana that the court is getting in the way of private prosecutions, with respect, his examples from Canada and New Zealand just demonstrate the point. Private prosecutions in other countries are not allowed to go unhindered. In most other countries, there is some sort of court scrutiny before you even get off the ground. Our legislature didn't require court scrutiny, but it did require certain requirements to be met, and they have not been met in this case, and there was plainly an abusive process. So very lastly then, on the injury question, with respect, the injury question was one that caused particular outrage, that it was said that that demonstrated arrogance and bigotry that it was persisted with. With respect, of course it's persisted with, because it is a point that is plainly with merit. And could I demonstrate this? My learned friend says, well, he didn't even know that Mr. Zuma had been waiting 18 months. He didn't know that Mr. Zuma had a life-threatening illness. But the problem with the argument is that it always conflates other facts with what is actually revealed by the letter. And I would ask the court to go and reread that letter. And I would ask the court to consider whether there is truly any disclosure of private medical information there. And in doing so, I would ask the court to have regard to what Mr. Justice Kun said, because it's true that Mr. Justice Kun did not decide the Section 41 issue. But what he did do is he made remarks about whether there had actually been private medical information disclosed. And I would ask you to have a look at page 247 of the Maughan bundle, paragraph 265, where Mr. Justice Kun says the letter is vague and general in terms and does not disclose any particularity which could be said to be a violation of Mr. Zuma's rights to privacy. And in fact, even in the argument in the 106, even in the argument on the postponement, our learned friend Mr. Mpofu said much the same. If you have a look at the Downer affidavit, which is at 689, paragraph 66, when Mr. Trengove complained, Mr. Mpofu replied, well, let me say this. Mr. Trengove says they are in the dark. Well, they are in the dark. They are in the dark. It's not a coincidence they're in the dark. We're all in the dark. He knows that the exact medical condition of the accused is a matter of confidentiality. So I don't know if he expected the doctor to go into that kind of detail in this letter. So Justice Kun knows that there's no detail on the medical thing. Mr. Mpofu knows that from what he said to Justice Kun. What are we still debating about the kind of injury that justifies this? So we submit with great respect that on each of those three grounds, the absence of a certificate, the abusive process, and the absence of an injury, the prosecution against Ms. Maughan falls to be set aside and interdicted. You did not hear one word about why an interdict was inappropriate, and we submit that both the setting aside and the interdict are appropriate. We also persist in seeking punitive costs. And you did not hear any argument as to why the punitive costs were inappropriate. They plainly are. And the statements that have been made today to say that these arguments smacked of bigotry and arrogance and the rest just make it worse. But you don't need to go there. All you need to say is that this was a hopeless prosecution from the outset. It should not have been persisted with when the application was launched. And the fact that it's been persisted with has led Ms. Maughan to incur unnecessary costs. And we ask for an order dismissing upholding the application and with a relief in the notice of motion, including attorney-owned client costs and including the costs of 2 counsel. My Lord and my ladies, I am indebted to the court and the court staff. Those are Ms. Maughan's submissions.
My Lord and my ladies, us will be similarly brief. I hope briefer. The first matter I want to address is the Rule 7 complaint. The State Attorney can't represent Mr. Dana. Now, one has to turn to the rules. We know what rules say. Mr. Zuma says he brings this complaint in terms of Rule 7. He says so in his answering affidavit. You then turn to Rule 7. Rule 7 says a complaint of this nature must be raised within 10 days after you're aware that the person is acting, or on a longer period on good cause shown to the court. In other words, you can go to court and say, I couldn't do it in 10 days for the following reasons. Please allow me to do it now. That was raised in the replying affidavit. So Mr. Zuma was on notice that his objection to the State Attorney was invalid. It was still borne because he had to comply with Rule 7. So what did he do? Did he then comply with Rule 7 and bring an application for a late filing of a Rule 7 notice? No, he ignored it. And what does his counsel say when he comes here? He says the court should also ignore it. Well, that's not how the law works. Our learned friend made an impassioned plea for equality before the law at the end of his submissions. The rules apply to everyone. They apply just as much to Mr. Zuma as to everyone else in the court, and he can't just ignore them and ask the court to ignore them. In any event, so the Rule 7, there is no valid Rule 7 complaint. In any event, I referred your lordships and your ladyships to the findings of the Supreme Court of Appeal in the case about Mr. Zuma's legal fees. And I trust the members of the court will remember what happened. There Mr. Zuma's private attorney had been paid by the State Attorney. And the court said there's no justification for it, no basis for it. And it then went on to say whether there would be a basis for the State Attorney itself to represent Mr. Zuma would depend on the facts of the case, the nature of the case, the nature of the interests, the public interest in the case, the government's interest in the case. All of those would have to be considered. But they weren't in the Zuma case because it was all done to a private attorney, which was unlawful to start with. If Mr. Zuma had in this case raised the objection to the State Attorney properly, he would have had to file an affidavit. We would have filed an affidavit by the State Attorney who explained why it was in the public interest and in the government's interest for the government to be represented, or for the State Attorney to pay. The National Director of Public Prosecutions would no doubt have filed an affidavit explaining why an instruction was given to the State Attorney to represent Mr. Dana. None of that happened because they don't follow Rule 7. And why don't they follow Rule 7? Apparently it doesn't apply to them. So the Rule 7 complaint is really without substance at a formal level, and it's without substance at a substantive level. Then on the question of non-joinder, I'm not going to repeat what my learned friend from Ms. Dana, Ms. Moore said. May I just read what was said? He quoted a 1949 case. Here's the 2015 case. It's called Fluxmans, Fluxmans versus Litos Corporation, Lithos Corporation. And the reference is 2015 2 SA 322. 2015 2 SA 322, a decision in the Gauteng division. Paragraph 30. In summary, I'm now reading the judgment. In summary, where a party has a direct and substantial interest in litigation and has been given formal notice of such litigation and waives the right to be joined in the circumstances amounting to a consent to be bound by the judgment, such joinder would no longer be necessary as the principle of res judicata would operate. And so that's the short answer. And for the sake of completeness, let me say that refer to the court to page 3 of the record in the Dana case, where you will see that the papers were served on Ms. Maughan's attorneys. So she was given notice of it, and she elected very sensibly not to participate. That brings me to the third point, which is the argument about the charge against Mr. Dana, which appears to be a charge of being an accessory after the fact. And I say three things in that regard. Firstly, if you want to know what the prosecutor's case is, you look at the summary of substantial facts. And there tells you what is the case that the prosecutor is going to make. And it's done in this case. Can I refer the court to the Dana record, page 52, paragraph 44. It may be helpful to go there. It's page 52, paragraph 44. And it's in the summary of substantial facts and after recitation of other facts, paragraph 44. Now, therefore, both accused, that's Dana and Morn, unlawfully and intentionally, without the authority of the National Director or such person designated by the National Director, respectively, authorized the disclosures. Well, let me stop there. The court knows that Mr. Breitenbach, that Mr. Dana did not authorize the disclosures. He tells you that, Mr. Breitenbach tells you that. So you know that he's not guilty of that. He didn't authorize the disclosures. Authorized the disclosures and disclosed the information and or content of the document. Well, you also know that Mr. Dana didn't disclose the document. He neither authorized the disclosure nor disclosed it. So the case of Mr. Zuma is utterly without any factual foundation. You know, as a matter of fact, on the facts before you, that Mr. Dana didn't authorize the disclosure and he didn't disclose the information. And that, with respect, is the end of the case against him. The case is simply fanciful. The second thing to say in this regard is that in this case, this is a case in which Mr. Dana alleges that the prosecution is obviously unsubstantiated. The answer to that must be to substantiate it. But there's no attempt by Mr. Zuma to substantiate the complaint against Mr. Dana, the accessory after the fact complaint. There's nothing at all, no evidence put up, no suggestion that any evidence even exists, undisclosed evidence. It's simply silence. Mr. Dana says there is no case against me. There's no evidence against me. Here's the evidence. Mr. Zuma says nothing. The third point I want to make in relation to the accessory after the fact issue is to take the court back, if I may, to what is an accessory after the fact. An accessory after the fact, according to Lawser, volume 11, 3rd edition, paragraph 136, an accessory after the fact is a person who, by his or her intervention, after the commission of an offense, assists the perpetrator or accomplice in evading detection of and prosecution for the offense. Assists the perpetrator or accomplice in evading detection of and prosecution for the offense. That's what Mr. Dana would have to have done in order for there to be any case against him at all. There's no allegation of that kind whatsoever in the papers. The case goes on and says, the Lawser goes on and says, mere failure to report the commission of an offense or mere approval of an offense is not in itself sufficient to render a person liable as an accessory after the fact. And that's what Mr. Dana is alleged to have done. He's alleged to have approved of what Mr. Breitenbach did. Well, whether he approved or not is irrelevant. It doesn't constitute an offense to approve. It doesn't constitute an offense to know about it. It constitutes an offense to do something to prevent the detection and prosecution. And the cases cited, there are 8 cases ending up with a 1998 case in the Supreme Court of Appeal, all explaining the same point, that the offense consists of assisting the perpetrator or accomplice to evade detection and prosecution. There is no allegation in the summary of substantial facts. There is no allegation in the answering affidavit. There is no allegation even in the heads of argument, not that you could make it there, that Mr. Dana has done anything of the sort. So the charge is simply, with due respect, nonsense. Receiving information is not a crime. Receiving stolen goods is a crime, but receiving information is not a crime. It's not a crime known to our law. Receiving information that a crime has been committed is not a crime. And so Mr. Zuma and his counsel, with respect, can't just make up the law to suit their case. They provide no authority whatsoever for the proposition that just knowing about it and doing nothing about it, which is their complaint, constitutes an offence. Then the next next matter is a related matter. It is, our learned friend says that Mr. Zuma is not going to prosecute Mr. Breitenbach, who was the source for Ms. Maughan. He's not going to prosecute Mr. Breitenbach. He's going to call him as a witness, and he's on the list of witnesses. Well, the court knows what Mr. Breitenbach is going to say. The court knows that Mr. Breitenbach, when he's called as a witness, is going to say that Mr. Downer did not disclose the medical letter. He's going to say that Mr. Downer did not authorize him to disclose the letter, that he did it off his own bat. And so, if that's the evidence on which Mr. Zuma relies, his case is sunk. It's finished. His own witness, and who he says he's going to rely on, who's the person who is not calling, he's not prosecuting him because he's a witness, is going to sink him. Because he's going to tell the truth, which is that Mr. Downer did not disclose and he didn't authorize. That brings me sort of patlangs to why then is Mr. Breitenbach not being prosecuted? The reason with respect is obvious. Because prosecuting Mr. Breitenbach will not assist, will not advance Mr. Zuma's cause, which is to delay the prosecution. If Mr. Breitenbach is prosecuted, and if he withdraws from the prosecution team, somebody else will have to be appointed. It will have no effect whatsoever on the prosecution, and so it won't cause a delay. So why bother to prosecute Mr. Breitenbach? Because it's not going to help in the strategy, and that's why we have this strange thing that the person who did disclose is not charged; he's a witness, but the person who didn't disclose is charged with disclosing, which he didn't do, or authorizing, which he didn't do. So that, with respect, is the end of the accomplice, the after the fact, accessory after the fact. My learned friend has dealt with what Justice Kuhn said about the disclosure of the doctor's letter, so I don't have to go there. Then I come to the United Nations guidelines on the role of prosecutors. And that is, again, an extraordinary argument. The argument appears to be that A, Mr. Downer did not comply with the United Nations guidelines on the role of prosecutors, and B, therefore, he's committed a criminal offense. That's what I understand the argument to be. Certainly that's how I heard it. Our learned friend shakes his head. Well, I'm going to, as the court may have heard it the same way as I heard it, I'm going to persist in that. That Mr. Downer didn't comply with the UN guidelines, and that a failure to comply with the guidelines is a criminal offense. Both of those statements are false. Firstly, Mr. Downer did comply with the guidelines. It's set out in paragraph 60 of our heads of argument. It's all fanciful because, anyway, but it's set out in paragraph 61 of our heads of argument. The paragraph 13D of the United Nations guidelines authorizes prosecutors to disclose matters that are necessary in the performance of their duties or when the needs of justice require such disclosure. One of their duties is to ensure that the public is kept informed of what's going on. We want not just a lively press, we want a well-informed press. And so it was within the scope of, it was part of the performance of Mr. Downer's duties that he spoke to Mr. Sol, and well, he didn't deal with Ms. Maughan on this in any event. So the first problem with Mr. Zuma's case is Mr. Downer did comply with the guidelines. The second problem with his case is that you will find nothing in the NPA Act which says that a failure to comply with the guidelines is a crime. What it says is that the NDPP, it's dealt with in paragraph 61 of our heads, in section 22(4)(f) of the NPA Act requires the NDPP to bring the UN guidelines on the role of prosecutors to the attentions of directors and prosecutors working for the NPA and to promote their respect and compliance. There's nothing in the Act. That's where the rules, that's where the UN guidelines are dealt with. There is nothing in the Act which says a prosecutor who does not comply with the guidelines is guilty of an offense. It's a very strange attempt to find, because no offense can be found under the NPA Act, section 61, an attempt is made to import it there. There's no such thing. Then, almost finally, I make the submission briefly in the light of the fact that my learned friend has addressed it more fully. There's only a token attempt in oral argument to answer the case that this prosecution is an abuse of the process of court. There's nothing in the heads of argument which deals with it substantively. It's dealt with briefly in passing, and there's no real answer to it in argument. I ask the court to go back to the founding affidavit and to read the founding affidavit, paragraphs 18 to 34. That tells you the timeline, the sequence of events, the sequence of the litigation in which Mr. Zuma has been involved, most of it at his instance, not at the instance of anybody else. It's paragraph 18, which starts at page 10, goes on for pages and pages, and it ends in paragraph 34 on page 16. I asked the court to just read that and then say, no abuse of process. How could one possibly reach that conclusion? My learned friend, Mr. Mpofu, complains about the statement in our heads of argument and in our oral arguments that Mr. Zuma has been unsuccessful in all of his matters. Let me read you what is in the founding affidavit. At the same place where I was a moment ago, it's now paragraph 35.2, page 16 of the founding affidavit. This is what Mr. Downer says, quote, he says, I highlight the following features of this timeline illustrative of Mr. Zuma's abuse. Quote, all his challenges have ultimately failed, but only after he had pursued them to the bitter end. Close quote. That's the allegation made by Mr. Downer in his founding affidavit. If you turn to the answering affidavit, I won't take a court there, it's paragraph 43, page 236, that's not denied. Now, I wasn't, this is the first time I'm involved in this case. I haven't been involved, blessedly, in the previous litigation. So when I was briefed with this, one of the things I went to check was, is it true that all of his applications have failed? And I found the founding affidavit, where it says, read it again, all his challenges have ultimately failed. And I turn to the answering affidavit, and Mr. Zuma does not deny that. He doesn't say, oh no, you've forgotten about Judge Simone, or oh no, you've forgotten about this. It's not denied. So we're entitled to say that, because it was alleged and it was never denied. Then, finally, on the question of the foreign jurist, I was going to make some remarks about responses to what Mr. Ngolwana said, but in the light of the lateness, I won't do that. What I will do is just say something briefly about the reliance on the foreign jurisdictions. The relevance of the foreign jurisdictions is not entirely irrelevant, because here we're interpreting the NPA Act and the CPA. But the one thing that emerges from the foreign authorities, all of them, is that they all have safeguards to prevent the abuse of private prosecutions. And the need for it is obvious, because a private prosecutor, by his or her nature, has an interest. It's somebody who has a grievance, a personal grievance, and he's coming and wants to be vindicated. And so they can't be expected to be, in the words, to be independent, and they can't be expected, in the words of the Constitution, to act without fear, favour or prejudice, because they're interested parties. They have a grievance which they want to pursue in the courts. And so there are systems to prevent abuse. And in Canada, the system which Mr. Ngolwana said he loves, there's a prior pre-trial process before a judge who decides whether the matter may proceed. Everywhere, there's a mechanism to prevent abuse of the power to prosecute privately, because it is a power which is inherently at risk of abuse. In our country, there are two mechanisms to prevent an abuse. The first mechanism is in Section 7 of the Criminal Procedure Act, which sets out the requirements for a private prosecution, the interest and so on. and a nolle prosecutor certificate. The second safeguard in our country and in our law is that the courts watch what happens and they will intervene to stop an abuse of that power. They will do that through the doctrine of abuse of process. They will do it through, they have done it again and again and again and again. They have done it in the civil courts, and they have done it because the courts are alert to the fact, and they refer to the fact in the various judgments. They say this power can be abused. A business person can use it, can prosecute his competitor to try to put the competitor out of business. These things have to be avoided, and so the abusive process doctrine is there to protect against the abuse of the private prosecution power. And who has, and all we ask in this case, and all we ask, and sorry, so the abuse of power doctrine exists inter alia to ensure no abuse takes place of the private prosecution power. And if the court finds it's an abuse either because it's for an ulterior purpose like delay, or because there's no case anyway, then the court intervenes, it sets aside, and it stops the private prosecution. That, my lord and my ladies, is what we ask this court to do. Thank you.
Yes, my lord.
I read your heads and the point that you want to raise, you mentioned the
Yes.
you still feel the need to say so?
My lord, if I may take 2 minutes to do so, with your leave.
Yes, I certainly object, my lord and my ladies. If she's given an opportunity, her request for time to address the court was on the basis that I would address the issue of whether or not she should be their admission as amicis should be revisited. That was the only basis on which she would ask for more time. She cannot now, late in the day, come up to try and address the same question. But if the court grants her the right to reply, I would ask to be given an opportunity to respond to what she says.
Thank you. My lord, if I may just address my learned friend's latest statement. It is not so that I requested an opportunity to address this court only if Mr. Zuma was opposing the admission of the amici. What we heard this morning was a different argument, and it was an argument which I addressed this court had an implication for the procedure. The point is this: Mr. Zuma consented to the admission of the amicus. Yes, but my lord, with respect, I haven't addressed the point that I wish to address this morning, which is a point about how this argument has been transmogrified. It has become an argument about why you mustn't take the Helen Suzman Foundation submission seriously. And that is a very serious submission to make.
The belief that you sought related to whether Mr. Masuku was right in trying to convince this court that you should not have been trained as an amicus in the first place. That's not the only basis. That's the only basis. We have passed that only.
My lord, as I addressed your lordship and ladyships this morning, the issue had changed. The issue had become a matter of process because they ran arguments relevant to the partisanship of the Helen Suzman Foundation in seeking to persuade this court to give less weight to those submissions. And my submission was those are only relevant to admission. So in fact, there is an argument which we still wish to address to this court. We beg an opportunity in the late day to put in further written submissions, if we may, on the topic. Thank you, my lord.
My lord, my lady, we're in the same position and we simply align with the Helen Suzman Foundation submissions. That's the court basis.
Are we done or is that big time?
I'm glad. Okay, I trust you.
No, but if they get a chance, could we also respond to the Downer submissions on Galwana submissions? Because we don't know.
Thank you.
No, I'm driving from the airport. Yeah. Can you reach right Masood? I'm going to the airport. Where's your daddy? It's in your car.
No, we'll be fine.
I'm so sorry. Which is yours? You guys checked in. But these are mine. Good. Yeah, just this first. I've managed to take them. I tried to take away your beds. No, those ones are, that's authorities and what have you. We don't need that. This time I'm going to leave.
Shabil.
Yes, I'm good. Let's go. No problem.